Minister.
Yes, thank you very much, Chair.
Point of order, Mr. Chairman.
Danny Kruger, point of order.
Before we get underway, I just wanted to check your ruling, or your get confirmation from you. My understanding is we're planning to go a bit later today, which is absolutely fine by me. I just wanted to get clarity from you that there is no hard deadline for this bill committee, that there's an intention for a report stage on the 20th of April, but if the committee wishes to go further, we can. And I'm just a little concerned by some of the remarks made in the committee this morning. People are conscious of time, and there's a sense of being asked to speed up as we go. But am I right in saying that this bill can take as long as it needs to, and in fact it should take as long as it has to debate this very important matter?
The short of it is yes, and I think members inevitably will deal with this in a sensitive and conciliatory fashion as possible, notwithstanding the point.
Thank you.
Minister.
Thank you very much, Chair. It's a pleasure to serve under your chairship today. I was just talking about Amendment 108 when we broke at 11:25. Clause 4, subsection 4, as currently written, sets out that a registered medical practitioner who conducts the preliminary discussion on assisted dying must, as part of that discussion, explain and discuss the person's diagnosis and prognosis, any treatment available and the likely effect of it, and any available palliative, hospice or other care, including symptom management and psychological support. Amendment 108 would supplement this with a requirement for the registered medical practitioner to also offer to refer the person to a specialist in palliative, hospice or other such care for the purpose of further discussion. The amendment adds an additional level of specificity to the discussion on palliative, hospice or other care to the preliminary discussion, but does not in itself place a duty on the registered medical practitioner to make such a referral or for the person to accept it. In considering whether this amendment is required, the Government may also wish to note that the GMC's good medical practice already requires doctors, when providing clinical care, to refer a patient to another suitably qualified practitioner when this serves their needs. As the committee are aware, the Government has worked with the member for Spen Valley on several amendments to ensure the bill is legally and operationally workable and reflects her policy objectives. Amendments 183 and 424 are two such amendments. The purpose of Amendment 183 is to emphasise, not change, the existing provisions in the bill that provide that the preliminary discussion held with the person by a registered medical practitioner must not discuss assisted dying in isolation. Rather, the discussion must reference the matters contained in Clause 4.4, including the person's diagnosis and prognosis, any treatment available and the likely effect of it, and any palliative, hospice or other care, including symptom management and psychological support. Turning to 424, this amendment seeks to clarify the definition of preliminary discussion in Clause 40 to align with the description of the discussions in Clauses 4.3 and 4.4. This is a drafting change. As per Clauses 4.3 and 4.4, a preliminary discussion takes place between a person seeking the provision of assistance in accordance with the bill and a medical practitioner about the requirements that need to be met for such assistance to be provided. The preliminary discussion must include A, the person's diagnosis and prognosis, B, any treatment available and the likely effect of it, C, any available palliative, hospice or other care, including symptom management and psychological support. 425 introduces a requirement that a person seeking assistance under the bill is referred to a multidisciplinary team to consider support and care for this person. The Secretary of State may provide regulations to determine what kinds of professionals should make up such a team. However, this amendment requires that at a minimum each team should include a medical practitioner or a nurse, a social worker and a psychiatrist. The obligation to refer to the multidisciplinary team would apply each and every time a person indicates to a registered medical practitioner their wish to seek assistance to end their own life in accordance with this Act. So there could be multiple referrals. I would finally note that there may be wider resource implications from this amendment, including for social workers. Chair, turning to Amendments 53 and 54, which I will speak to as one, these amendments propose changes to Clause 7 rather than Clause 4, as we've been considering so far today. The effect of the amendments is that, in carrying out the first doctor's assessment, the coordinating doctor must, in addition to the other requirements, be satisfied that the person has relevant and available palliative care options. As such, these amendments would mean people are only eligible for assistance to voluntarily end their own lives when they have relevant and available palliative care options. This amendment would create an additional criterion which may reduce the number of people able to receive an assisted death, linked to the availability of palliative care services to any given individual. Amendment 426 prevents the coordinating doctor from finalising the first assessment process until they've received confirmation from a multidisciplinary team, as set out under Amendment 245, that the person seeking assistance to end their own life has met with the multidisciplinary team. The committee may wish to note that under this amendment there is no requirement on the multidisciplinary team to provide this confirmation in a given time frame. This may lead to delays in the coordinating doctor being able to make their statement and onward referral. Amendment 286 removes the existing requirements in Clause 9 to subclause 2A to C of the bill and inserts 3 new requirements. The 3 new conditions require the assessing doctor for both the first and second assessment to consult with specialists in relation to the person's diagnosis and prognosis, any treatments available and the likely effect of those treatments, and any palliative hospice or other care, including symptom management and psychological support. The committee may wish to note that, as drafted, the amendment may have some unintended consequences. This is because, by replacing Clause 9.2a, 9.2b and 9.2c, the amendment would remove the words explained to and discussed with the person being assessed at Clause 9.2b. Consequently, the amendment would remove the requirement for the assessing doctor to have a discussion with the person about the factors currently set out in Clause 9.2b. The assessing doctors would also not be required to examine the person and their medical records and make other inquiries as they consider appropriate. Amendment 286 could also lead to a significant loss of essential discussion between the assessing doctors and the person seeking assisted dying. The removal of Clause 9.2b eliminates the requirement to explain and discuss the diagnosis and prognosis, treatment options and palliative care. Additionally, this amendment removes the requirement to discuss the person's wishes in the event of complications arising in connection with the self-administration of an approved substance, which may be seen as important for fully informed decision-making. Chair, that concludes my remarks for this grouping of proposed amendments, and I thank the committee for its attention.
Peter.
Thank you, Chair. I'll try and keep my comments as brief as possible because we had another very thorough discussion. I'll speak briefly to my Amendment 424 first of all. This is, as the Minister has said, a simple drafting change in Clause 40, which confirms that the preliminary discussion means a discussion as per Section 4, subsection 3. With regard to Amendment 275 from the Honourable Member for Sunderland Central, this clause would in many circumstances broaden the scope of the conversation that the doctor would have with the patient, and I am happy to support the amendment. If I come to Amendment 108 from the Member for East Thanet, Chair, again, as I've said, I'm very happy to support this very sensible amendment. I think it's perfectly acceptable to ask the doctor to offer to refer the patient to a specialist, as they would probably do in most cases anyway, but for clarity. And if I come on to my Amendment 183, I refer colleagues to the comprehensive comments from earlier in the session in relation to this amendment and the support of the BMA. Following the second reading debate, I listened very carefully to concerns of members about the possibility of doctors only discussing assisted dying with patients. And even though the bill does state that this cannot be the case, for the avoidance of any doubt, this amendment emphasises that the initial discussion mentioned in subsection 3 may not be conducted without also explaining and discussing the matters mentioned in subsection 4. And accordingly, such a preliminary discussion may not be conducted in isolation from an explanation of and discussion about the matters mentioned in paragraphs A to C, i.e. doctors cannot discuss the option of assisted dying in isolation, only in conjunction with all other available and appropriate treatment. Indeed, Andrew Green from the BMA told us some patients find it very difficult to bring up sensitive subjects with their doctors, even when those are the most important thing on their mind. He asked us to please don't pass legislation that makes it harder for doctors to understand their patients. And that concludes my remarks. Thank you, Chair.
Thank you. Ali Kruger.
I'm not speaking any further.
Okay.
I spoke earlier. I'm happy to move when time comes.
Okay, in that case, we have the amendment before us. Yes, do you want to press 342?
No, I'm going to withdraw it.
Okay, so is everyone content for the amendment to be withdrawn?
Aye.
Amendment by leave withdrawn. Thank you. Excuse me. Amendment 270 to Clause 4 in the name of Dr. Andrew Morrison has already been debated with Amendments 278. I call Danny Kruger to move the amendment formally. Amendment 270 to Clause 4, as on the amendment paper. The question is that the amendment be made. As many as that opinion say aye. Aye. On the contrary, no.
No.
Well, do you wish to go to a division? Yes. So. Fine. Division. I think everyone's in the room. Lock the doors. Yes, everyone are happy to proceed? Yes? Okay. Now lock the doors.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojan Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater. No. Kit Malthouse.
No.
Dr. Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile-Roberts. Naz Shah.
Aye.
Dr. Neil Shastri-Hurst.
No.
Dr. Marie Tidwell.
No.
Sean Woodcock.
Aye.
The ayes were 7, the noes were 12, so the noes have it. 13, beg your pardon. 7, 13, so the ayes, the noes have it. The noes have it. Unlock the doors. Now we now come to Amendment 414 to Clause 4 in the name of Jack Abbott, with which it will be convenient to consider Amendments 414, 413, 415, 416 and 417. I call Liz Savile-Roberts to move the amendment.
Diolch yn fawr iawn. Thank you very much, Mr Chair. And I rise to speak on Amendment 413, which requires in Wales for a medical practitioner conducting a preliminary discussion under subsection 4 to also discuss with the person their preferred language of Welsh or English. And I would also like to move amendments 414, 415, 416, 417 for the member for Ipswich. Although I must, and these are related to adjustments for language and literacy barriers. I will speak on these, but it's not my intention to divide on these. I would point out here now, although I am supportive of the concept that the drive behind the member for Ipswich's amendments, these are in a very different situation to those related to Welsh and English, because the use of Welsh and English have particular statutory implications. This is the first time I have risen to speak about how we need to tease out the implications of this bill in the context of reserved and devolved powers, where justice and criminal law are reserved while health and social care are devolved. Amendment 413 concerns the need, in my belief, to place on the face of the bill whether the person wishes to use either Welsh or English in their initial discussions with registered medical practitioners. I firmly believe that this needs to be written into legislation at this stage. And I also have later amendments to Clause 5 and Clause 8 and also new Clause 18 and amendments to new Schedule 2, which again relate to the use of Welsh. I will take a few interventions, please.
Thanks, Chair. Thank you for giving away. I fully support this amendment. My question, Chair, is the amendment says the practitioner conducting the preliminary discussion should use an interpreter. Shouldn't we be thinking that the interpreter should be available for all the interaction following on from the preliminary discussion?
Well, I agree with him in principle. I'm not having to operate within the law in terms of Welsh and English because there are legal considerations, particularly with those two languages. But it is evident in the matter which we are discussing, the ability for the person to be able to communicate as as directly as possible is obviously of the greatest importance. I would wonder whether there could be a response from ministers that the codes of practice in clause 30 will be sufficient to this, but I will emphasise that I took advice from the Welsh Language Commissioner's Office, and it was the Welsh Language Commissioner's officer who advised that I put these amendments down. So I think we do need, because we are operating in unique circumstances with the Private Members Bill, we really need to have clarity on exactly what is required to be where in relation to how this operates between England and Wales. I would, of course.
Thank you. She will know that in 1993 the Welsh Language Act put the Welsh language on an equal footing with the English language in Wales. So does she agree with me that the clarity that would be helpful would be to understand if the provisions in that Act apply to this bill?
I'm really grateful for her intervention. I think that is exactly what I am seeking to do, and I am seeking to do this as cooperatively and as collegiately as possible. But I think we do need to have clarity on this, and the nature of our discussions need to be thorough, to be accurate on this. Now, when it comes to the individual's right to use Welsh in their daily lives, there are two pieces of legislation relevant to this bill. Welsh Language Act 1993, which predates devolution, and the Senedd's Welsh Language Wales Measure 2011. The Welsh Language Act remains applicable for reserved matters such as justice, and the Ministry of Justice operates a Welsh language scheme which enables, of course, people to use Welsh in courts and tribunals and other areas of justice. The Welsh Language Measure established the Office of the Welsh Language Commissioner, who has the power to investigate complaints from Welsh speakers who assert their freedom to use Welsh when that has been interfered with, creates a Welsh language tribunal to hear appeals against the Commissioner's decisions, and enabled the development of Welsh language standards, which are significant to us today, particularly significant. The Welsh Language Measure states that individuals in Wales should be able to conduct their lives through the medium of Welsh if that is what they choose to do. Under the measure, the NHS in Wales therefore has a statutory duty to deliver services to the public in both Welsh and English. Welsh language standards are a set of statutory requirements setting out responsibilities to provide services, and they apply to health boards in Wales as well as NHS primary care services that are contracted by the health boards. Standards do not apply to independent providers who must, however, since 2019 follow 6 Welsh language duties, one of which is to establish and record the language preference of patients. And that is where I've got the terminology that is used for this Amendment 413. Now, that's a summary of the relevant considerations. But before I close, I think it really matters why, it's really important to say why this matters to Welsh speakers. Now, I spoke recently to medical practitioners in Wales who really wanted me to emphasise their concerns at the lack of specific mention of language rights, and also, of course, to the Welsh Language Commissioner's officers who advised me on the necessity, again, advised me on the necessity of these amendments. But to come back, why this matters. Now, there is a critique against providing Welsh language services that shrugs its shoulders and says, why bother? They all speak English anyway. But that is to ignore how integral language use is to the individual. We're drafting a bill to do two things in a very delicate balance: to respect the autonomy of the individual and to safeguard people against abuse in any form. Now, for many, many, many Welsh speakers, Welsh is the language of their emotions. This is the language in which they express themselves most fluently. This is the first language of their feelings, and that matters to this bill. That matters. English is the language of authority, and many Welsh speakers are anxious not to challenge the authority of high-status people like doctors. They do that out of politeness, ingrained politeness, and also out of fear of not being able to access services if they put any barriers in the way. Yeah? So this is a way that language gets used. Welsh speakers don't use Welsh in the way that monolingual English speakers use English. We use English as monolingual English speakers because that's the only language we have. But for anyone who is bilingual or multilingual, the use of language is very complicated and very sophisticated, and we need to be alert to it in all its respects. Now, That for us, I think, to come back to that, the nature of the relationship between doctors and their patients, the high status, the person who approaches the doctor in seeking services, seeking advice, seeking that context. This is not a power dynamic that we should allow to go unchecked. That's why I would urge the committee members to consider this amendment. I am not going to push it to a vote today because I really want to hear from the ministers what their response is to this. And I really, before we get to report stage, want to have absolute clarity as to the legal necessity or otherwise of this. But I instinctively feel, because of course the Welsh Language Commission's office had also told me that this should be on the face of the bill. So I await their response, and I would also like to have a response to the Honourable Member for Ipswich's amendments as well. Thank you very much, Chair.
Rebecca Hall.
Thank you, Chair. I would like to speak briefly on Amendment Abbott 414 and Savile Roberts 413. I think these are very thoughtful, well-considered amendments, and the Honourable Member has just set out very powerfully and persuasive how important this is, so I thank her for that. I am supportive of these amendments. I would suggest, though, that we probably need to go further in reality and specify exactly who would be interpreting and make sure that it's regulated and in a reliable way. What we don't want to do is just have, anyone who happens to be able to come in off the street and do that isn't relevant, isn't appropriate in this instance. So we do need to think about whether we need to go further with this. But I think this is a great starting point and a move to more where we need to be. I think there's much subtlety in the debate, and I think we've talked a little bit in the first week about the importance of the language and the words that are used. And I think one of the things we always need to be very cognizant of is that when we are imparting information to people, particularly in a healthcare context, it's vital that we use words and language that people understand so that it is clear the ramifications of what is being discussed. And I think this is where these amendments become really important, because those where English isn't their first language, some of that subtlety, that nuance around what a term actually means could be lost. And I think interpreters could be an important part of adding that clarity that is required to ensure everyone going through this process understands exactly what it involves. I think it's important to recognise that a 2024 Nuffield Council of Bioethics survey found that 39% of people think that assisted dying means withdrawing life support. 19% think providing people who are dying think it is providing people who are dying with drugs that relieve symptoms of pain or suffering, and 13% think it means providing hospice care, which I think just demonstrates the debate that we had a couple of weeks ago about assisted dying can be interpreted in quite a few different ways. So it's really important that we are really clear in the language we use and what we mean by that. What we also find is that amongst ethnic minorities, there is sometimes a greater misunderstanding about palliative care. A 2024 survey from King's College London found that 6% of people believe it is accurate that palliative care involves giving people medicines in order to shorten their lives. But 18% of people from ethnic minority groups think this. So I think, again, we need to be really cognizant of that. 18% of people trust healthcare providers not very much or not at all to provide high quality care towards the end of life. Whereas again, when you look at ethnic minority groups, that increases to 30%. 6% of people say they have not heard of palliative care, again compared to 22% of people in ethnic minority groups. I think the other piece that's important to recognise as well is that the text of the amendment is much less stringent than in South Australia's law, Clause 7, which strictly regulates interpreters. So this goes back to the point I was making at the beginning. And so under the South Australian law, they must be accredited by a prescribed body. So they can't be a family member, they can't stand to benefit from the will or be involved in the patient's healthcare. I think it's really important that we want to make sure it is a recognised professional that is involved in this most important of processes and information sharing. I will just close by saying that I'm supportive of these amendments. I do think they need to go a little further, but I look forward to hearing what everyone else has to say on it.
Thank you. Daniel Francis.
Thanks, Chair. Really, just to echo the points that have already been made about the importance of those initial conversations, particularly for those that English isn't their first language. I did commit to my honourable friend from Ipswich, who isn't here, that I would move 414 and 415 to a division, which is what he requested. So it was really just a brief stand to say that I will move those to a division in his absence, if that's allowable, Chair. But I do support the general principles of those, that for those that are seeking interpret or need interpretation to explain the aspects of assisted dying to them, that I do support that, the merit of that, and the intention in amendments 414 and 415, which, with your permission, I will move to a division.
Thank you, Nasha.
Thank you, Chair. Like the member for Reigate and Dwight, I do support I won't be pushing it to a vote, but I do certainly want to speak to these amendments, simply because I think there are some, they don't go far enough. And the reason I don't think they go far enough, and as with the Welsh language, when people have that courtesy of seeing English as a superior or a powerful language, if you put yourself in the position of people of colour, that's an extra layer of an intervention that I don't think this quite captures. And then we've not even talked about BSL in all of this when we're talking about languages. I think that's really, really important. So, the Chair, I'm a qualified interpreter from Urdu to English in health, funnily enough. And I can tell the committee that if you were in Urdu, there isn't even a word for depression. There isn't a word, does not exist for depression. So when we're talking about health inequalities, and I chaired a mental health charity in a previous life, they're the largest mental health charity outside of London for ethnic minority communities, I understand acutely through patient intervention, and I'm a former NHS commissioner as well, I understand acutely the differences and the nuances of language when you're translating from one language to another. So in the first instance, you have a language which you don't understand. In a second instance, in terms of Urdu in particular, or some minority communities, Punjabi, Urdu, Hindi, those languages from the South Asian subcontinent, the words don't exist to literally translate from the words that would be in this bill, or to talk about assisted death. And it speaks to what the Honourable Member from Reigate was talking about, is that understanding of what it means. If I just, looking at the stats, what she quoted, I had the same stats, funnily enough, that actually people don't understand what assisted death is. So for me, there's something about how will we strengthen, and I'd really value the Minister's and the sponsors' contribution or responses to these questions. How do we ensure the nuances of having such a difficult conversation? Because these are really brave conversations on both parts of whether it's from the doctor's side or whether it's from the patient's side. So we have a patient. If I was to take a woman from an ethnic minority background whose English isn't her first language, and the doctor isn't able to translate and carry through that conversation with that person, would that be disempowering? Would it be empowering? Would we be doing a disservice to that person, with all the best will in the world from the doctors? And I think that I really would like to understand what considerations are being made to make this accessible, if it is to be a service, legislation which is equal to all. And this is where I've mentioned this a few times and raised it with the Minister, and I appreciate the Minister's responded, but this is where my frustration, for want of a better word, comes from, of not having an impact assessment in the first instance. Because had we had an impact assessment, these are the things that governments will look at. These are the things that you would survey at. These are the things that even for small bills, we go out for weeks and weeks for consultation. And on this one, we've not spoken to anybody during the course of this committee around the provision of languages and the nuance of languages and what that means for those patients. So for me, whilst I do support the essence of the attempts of all the members regarding these amendments, they fall short of those protections which are needed. So I don't know how that is going to be addressed by the government. I'd also, maybe perhaps on this particular amendment, maybe the Minister can enlighten me. If we have an impact assessment, once we've gone through the Bill Committee, then how do we use that impact assessment to then affect all these clauses that we've already been to or been through that we won't be able to comment on again? And I don't know how it works because I've never, many of us in here, it's the first time I've been a member of a Bill Committee. So and my understanding is usually the process is very different. So for this amendment, should the government go out and should the government's impact assessment shed light on the amendments that we are debating, and actually something significant comes up in terms of the government's assessments right now on whether these amendments are workable or not workable, or they will complicate things, etc. Once those impact assessments come back, where will we be then? Where does that leave us as a committee to strengthen this bill? Will it be done in the wash-up stages? Will it be done through report stages? I'm not sure. So I'd really like to understand that. So again, won't call this a vote, but I think it's a safeguard, it's a step in the right direction. Does it address my concerns? Unfortunately, not. It still leaves a lot to be desired. Thank you, Chair, on that one.
Julia Campbell. She raised the point I was going to. Thank you. Excuse me. Minister.
Thank you very much, Chair. This group of amendments focuses on language and literacy barriers, including discussion of the use of interpreters and translations. If Amendment 414 were to be passed, a registered medical practitioner who conducts a preliminary discussion with a person must first ensure the provision of adjustments for language and literacy barriers, including the use of interpreters. It may be helpful to note that in all areas of practice, registered medical practitioners must uphold the standards in the GMC's Good Medical Practice, which includes provision of adjustments for language and literacy barriers. The purpose of Amendment 413 is to require medical practitioners in Wales who are conducting the initial discussion outlined in Clause 4 to discuss with the person their preferred language of Welsh or English. It may be helpful to note that under the Welsh Language Measure 2011, the NHS in Wales has a statutory duty to deliver their services to the public in both Welsh and English. This legislation gives the Welsh language official status in Wales, and the measure states that individuals in Wales should be able to conduct their lives through the medium of Welsh if they choose to do so. The Welsh Government's active offer for health is intended to support all staff across NHS Wales to provide a service in Welsh for patients without them having to ask for it. Technically, I would note that the amendment does not require the medical practitioner to conduct the initial discussion in the person's preferred language or to refer the person to another medical practitioner who can conduct it in the person's preferred language if they are unable to do so themselves. I discussed this with the Honourable Lady. I'm more than happy to have a further discussion about how her amendment might work. I think the concern I simply flagged was we have the 2011 measure, and as with so many of these things, there's a law of unintended consequences, and an amendment which may be designed with the best possible intentions could end up disrupting a system and causing confusion and uncertainty, which I'm sure she wouldn't want to happen. So that's as with all of these things, that's the challenge.
Thank you very much. I want to we've raised already in the committee the need for an impact assessment, and I've also raised with the Minister the need for an impact assessment in Wales. I think the fact that we are having this conversation here shows that there's an element of uncertainty exactly whether this is necessary on the face of the bill or otherwise. I am concerned that it could be in a code of practice, and I share the Honourable Member for Bradford West concern that we don't actually know how these are going to operate or that we have any say over how they operate here as well. But given that he has come to this in the spirit of cooperation, I hope that we will find some clarity, and if it does appear that it is better for Welsh language speakers for this to be on the face of the bill, I hope that he will agree on that respect.
As I say, happy to have that discussion and to better understand how all of that might work in practice. If Amendment 415 were to be passed, it would mean that when making an assessment under subsection 2, the assessing doctor must first ensure the provision of adjustments for language and literacy barriers, including the use of interpreters. As with Amendment 414, the committee may want to note the existing standards that all medical practitioners must uphold, which include requirements for provision of adjustments for language and literacy barriers. Amendments 416 and 417 refer to clause 30, which as drafted states that the Secretary of State may issue codes of practice on a number of matters, including on arrangements for ensuring effective communication and the use of interpreters. These amendments would impose a duty on the Secretary of State to issue one or more codes of practice in connection with arrangements for ensuring effective communication, including the use of interpreters, and to do so within 6 months of the passing of the Act. The requirement to issue any such code of practice within 6 months may prove unworkable. Under clause 30, it would be necessary to consult on the code of practice, make regulations to allow for the code of practice to come into force, have the regulations approved by both Houses of Parliament, and then issue the code of practice, all within a 6-month period after the passing of the Act. As I said earlier, Chair, the Government will continue to remain neutral on whether or how the law in this area should change. That is, as I've made clear, a matter for this committee and Parliament as a whole. However, I hope these observations are helpful to members of the committee in considering the bill and the amendments put forward by members. Thank you, Chair.
Kimberly Peter.
Thank you, Chair. On Amendment 413 from the Honourable Lady from Plaid Cymru, with apologies, I might not embarrass myself by trying to pronounce the wonderful name of her constituency. I'm very sensitive to issues around devolution. And we have had many conversations about this, which I'm very happy to continue. The Minister has confirmed, as I understand it, the issue around Welsh language, in that it would be covered by the Welsh language legislation, which states that individuals in Wales should be able to conduct their lives through the medium of Welsh if they choose to do so, which is something I'm very supportive of, but I'm also very happy to continue those conversations with the Minister where necessary going forward. On Amendments 414 and 415, I think several members of the committee have had the same message from the Honourable Member for Ipswich, who is clearly struggling to get here on time, and I would also be very happy to move those in his name. They seem very sensible amendments, which I'm happy to support, and along with the GMC's Good Medical Practice, which sets out the principles, values and standards of professional behaviour expected of doctors, this is a very belt and braces approach on what is a very important issue for the reasons several members have said. I can't support, however, 416 and 417 due to the time frame they would impose, which would not fit in with the rest of the bill in reference to the 2-year implementation period, and it may just not be workable or possible. Thank you, Chair.
Thank you. Liz Saville-Roberts.
Thank you very much for the opportunity to speak. I withdraw 413 as things stand because I anticipate further conversations on those matters.
Okay. In that case, just for clarity, I'm going to ask if everyone's content for the amendment to be withdrawn. Yeah, sorry, you meant 413, 414, not 413. I'm going to ask people, colleagues, if they are content for the amendment to be withdrawn. If you're not content for the amendment to be withdrawn, I'm sure some people will, some people won't. So just simply say no when I ask the question. So is everyone content for the amendment to be withdrawn? Aye. Okay. Amendment by leave withdrawn. Right. Amendment 285 to clause 4 in the name of Rachel Maskell has been already debated with Amendment 278. I call Naz Shah to move the amendment formally. Amendment 285 to clause 4 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. No. Division. Is everybody here? Not everyone's here, but we can tend to go on. Yes, okay. Now lock the doors. Lock. Two.
This is 285. The Chair asked if everyone was content with
I thought that was 413.
414.
Abbott being withdrawn, is it? I thought it was Liz's.
414.
This was withdrawing 413, which is her amendment, but Daniel was moving Abbott 414.
Once you've gone past it, once you can't speak past the agenda, you can't.
Once we've gone past 414, we can't do that one, regrettably. So. Sorry, we've.
Members of points of order. I think we should be doing this.
Yes, if you have a point of order, make a point of order.
Sorry, Chair, just point of order. So have we gone past 414? I know we go back and forth because of the way the amendments appear in the original amendment list. So, but I had formally said that I wanted to move 414, but I'm not sure if we've got there or we've passed that point.
414.
Yes. 414 was yes. 414 is the lead in the group, so that was what was moved. That was moved. 414 was moved. That was the one that was moved, and not 413. And in that regard, that was the one that was withdrawn.
Point of order. Could I ask, Chair, whether I could not just withdraw 413?
No. No. Point of order.
I'm so sorry, I totally appreciate the confusion. I'm confused as well, but I think it was clear that the Honourable Lady, when she was invited to withdraw, thought she was withdrawing 413. Whereas the Honourable Gentleman, I think the whole committee expects to have the opportunity to vote on 414. I wonder if it's not possible to, just in light of the fact there was a little confusion, to revert.
Well, yes, I did say 414. However, for this, I accept that there was some confusion, but for the sake of it, I will ask if people are content for Amendment 413. 414 to be withdrawn. Okay, so we're clear.
No. 414. So we unlocked.
Are we unlocked?
Yes.
Okay.
Okay, so should we do 414?
Okay.
414's already been moved, so we just want to...
Amendment 414 proposed to clause 4 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. I think the noes have it. The ayes have it. The ayes have it. Okay. Amendment 285 to clause 4 in the name of Rachel Maskell has already been debated with Amendment 278. I call Naz Shah to move the amendment formally. Amendment 285 to clause 4 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. No. Division. Lock the doors, yes. Lock the doors.
Jack Abbott.
Right, we're voting on Amendment 285 to clause 4 as on the amendment paper. And I've said as the amendment is that the question is that the amendment be made.
Jack Abbott.
No.
Lewis Atkinson.
No.
Juliet Campbell. Aye. Bambos Charalambos.
No.
Daniel Francis.
Aye.
Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Daniel Kruger.
Aye.
Kim Ledbeater.
No.
Kip Malthouse.
No.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts. Naz Shah.
Aye.
Dr Neil Shastry-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 7, the noes were 14, so the noes have it. The noes have it. Unlock. Amendment 343 to clause 4 in the name of Anna Dixon has already been debated with Amendment 342. I call Sean Woodcock to move the amendment formally.
I withdraw.
Not moved.
Okay, not moved. Amendment 34. Yes. Yes, Amendment 344. Would you wish to move Amendment 344?
I do also.
Okay. Amendment 275 to clause 4 in the name of Lewis Atkinson has already been debated with Amendment 342. I call Lewis Atkinson to move the amendment formally. Amendment 275 to clause 4 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. Okay. The ayes have it. Amendment 108 to clause 4 has already been debated with Amendment 342. I call Sean Woodcock to move the amendment formally.
Formally moved.
Amendment to 108 clause 4 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. Amendment 183 to clause 4 has already been debated with Amendment 342. I call Kim Leadbeater to move the amendment formally.
Move formally, Chair.
Amendment 183 to clause 4 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Amendment 71 to clause 4 in the name of Ben Spencer, with which it would be convenient to consider Amendment 72, 73, 75, 74, 76, 77, 78, 79, 80 and new clause 4. I call Danny Kruger to move Amendment 71.
I'm very grateful to you, Mr. Chairman, and I want to just start by saying that while these amendments may, in a sense, appear irrelevant to the bill, because I don't think any of us here wish to see the creation of a assisted dying agency, nevertheless, I am grateful to my honourable friend, Member for Runnymede, for moving these amendments. He's playing his usual role of keeping us honest, because the fact is it's extraordinary, Mr. Chairman, that nowhere in this bill is it laid out exactly how the assisted dying service would be delivered in our country, whether it would be an NHS service, a private service, some kind of mix of the two. So I'm very grateful to him for being clear in his suggestion that this should be a non-NHS service, and that if we're to pass this law, we should establish a bespoke agency for the explicit purpose of delivering this service. It's a rather macabre, but I suggest a logical way of delivering on the proposal of the bill. And the fact is that many doctors, faced by the prospect of being asked to participate in assisted dying, have expressed their preference for it to be outside the NHS. And I will quote from the BMA, who have been cited a number of times already today. As they say, there is nothing in the bill about how an assisted dying service might be delivered, except although the possibility of a separate service is mentioned in the explanatory notes. And their view is that, I quote, assisted dying should not be part of the standard role of doctors or integrated into existing care pathways. So I stress that point because it's often suggested in the course of this debate that the way this will work will be as part of a holistic range of options, pretty indistinguishable from palliative care or other treatment options that are put before patients. The BMA are clear that it's not something, as they say, it is not something the doctor can just add to their usual role. The Royal College of GPs have also said in evidence to us that the shape of the service is not set out in the bill.
Point of order, Chair. Very sorry, Chair. I'd like to seek your guidance, if I may. In his opening sentence, my honourable friend said that none of us want to see the creation of an assisted dying agency. Now, my interpretation of us speaking to a particular amendment means we have to address what the amendment is intending to do in the bill. Now, the honourable gentleman said that he doesn't want what the amendment is intending to do, and he's speaking more generally about delivery of the service, and I wondered if we could have your guidance as to whether that's in order. Because one of the problems we've got is we're having very expansive debates, and I know previous chairs have sought to keep everybody in order, but I'm anxious that the Honourable Gentleman doesn't exhaust himself by straying from the central point that's in the amendment.
The fact of the matter is that the Honourable Member doesn't have to agree with the amendment in that regard, so he's perfectly entitled to speak in that regard. Danny Kruger.
I'm very grateful to you and to my rather honourable friend for his concern for my welfare, which is much appreciated, but he'll be relieved to know I have plenty of energy and can keep going. But no, I mean, speaking seriously, it is very, very germane to the bill that we are debating that these amendments are considered, because as I've been explaining, GPs and other medical practitioners have been very concerned about the absence in the bill of clauses to specify the delivery of the service. So I'm grateful that we've got this opportunity to discuss that and to hear from the Minister and the sponsor how they imagine the bill would operate and whether indeed it would be appropriate to establish some kind of agency along these lines. The reason I object to assisted dying agencies is because I object to assisted dying. I do actually see the logic of this proposal if we proceed with the bill, with this principle of the bill. So I do think it's extraordinary this crucial question is not set out. Chris Whitty, in his evidence to us, said rather airily that it was for Parliament to decide how the service should be delivered. I would stress that most medics involved in particularly in palliative care and care for people at the end of life are very hostile personally to the suggestion that they should participate in assisted dying. So the BMA's survey of members in 2020 found that 76% of members of palliative medicine doctors were unwilling to participate if assisted dying were legalised. The Royal College of Physicians 2019 members poll found 84% were opposed. So
there's nothing to do
no, but if you wish to make a point of order, feel free to make the point of order.
I'm grateful, and I'm sorry to interrupt. I don't mean to be rude, but I cannot see how this is germane to the actual amendment that we are considering. We have a lot of amendments to deal with in detail, and expanding the debate into a wider debate about whether the medical profession agrees or not with assisted dying does not seem to me to be addressing whether we should put this amendment on the face of the bill, which is what we're here to decide.
The Honourable Member is perfectly entitled to express his view, and I respect that view. And I will make a judgment as to whether or not, in due course, whether the Honourable Member is stepping outside the latitude of the issue. At the moment, Danny Kruger, but he will no doubt bear in mind your intervention and my response to that intervention.
Great.
I'm very grateful too. I do stress that what I'm discussing here is the suggestion, according to the amendment, that assisted dying be taken out of the NHS, not be part of the normal pathways that doctors are invited to participate in. And it does strike me as relevant that most doctors would wish this. They would, if the law were to be passed, they would wish something along the lines of this amendment, to be included. Now, we don't know exactly how it would work. We do know it could be potentially private, according to the scheme set out in the amendment. It could be within the NHS. We know from the references in clause 40 that private provision is envisaged because there's talk of reasonable remuneration for provision of services. So this is something that would be outside the normal service expectation of medical professionals employed by the NHS. Indeed, we know it could be a lucrative market. Happy to give way.
Thank you, Chair. What do one member think if we bringing an agency outside of NHS, private sector, this will become like a business?
Well, I'm grateful to the Honourable Gentleman, thank you, Chair, because he's absolutely right. The opportunity is there within the bill for private businesses to be established to deliver assisted dying services. And indeed, it would be a money-making enterprise, quite a lucrative one. There have been estimates given of between 5,000 and 17,000 assisted deaths per year, depending on how it's estimated. If the charges employed by Dignitas, which is in a sense the model being proposed here, if they're anything to go by, this could be up to the region of £5,000 to £10,000 per patient. So even a small proportion of that would be a significant, a multi-million-pound business would be possible under this bill. And we know that advertising would probably be possible for it. We saw the TfL suggests that the dignity and dying's adverts in the tube before second reading were compliant. There's no prohibition on advertising in this bill. There's no prohibition on people making money from it. However, the bill also specifies that it's a state-protected service. So if it were to be a private enterprise, it would have all sorts of state protections that would not normally apply to private providers of anything. So Clause 25, the providers would be exempt from any civil liability for providing assistance under this Act. Death will be exempt from investigation under the Coroners and Justice Act 2009, that's in Clause 29. In Clause 30, it says that a failure to comply with any code of practice would not of itself render a person liable to criminal or civil proceedings. So the fact that the only monitoring that would be done would be undertaken by the Voluntary Assisted Dying Commissioner, who's not an independent figure, but he or she is the person responsible for setting up the panels that approve the death. So,
Order. I think we really do need to get the issue back to the Assisted Dying Agency. So, could the Honourable Member deal with that, please?
I shall, and I'm winding up now, Mr. Chairman. But this amendment goes to the heart of this great absence, this sort of blank space in the middle of this bill, which is how on earth it would be delivered, who would deliver it, under what regulation, what would be their terms of engagement. All of that is, I think, quite a scandalous gap in the bill. So, just to conclude, my concern is with this enormous gap, and I want to just end with a reflection on this lack of clarity. Elizabeth Gardner, who I understand was the drafter, the very experienced parliamentary drafter who contributed her time to draft this bill, she's been quoted saying on the Hansard Society podcast that if the opportunity that drafting has to change the law, and if she says if it's a restriction that would curtail the ability of this to be delivered through the NHS, the bill could change that. So it's been suggested that the implication of this bill would require changes to the 1946 NHS Act to remove what the Hansard Society calls the duty to protect. I quote, to secure improvement in...
The Honourable Gentleman has heard what I said earlier on, and I don't want to reaffirm it again, but can we get back to the substance of the Assisted Dying Agency issue, please?
Okay, well, I've got one last point to make, which, Mr. Chairman, I hope you'll regard as in order, because, as I say, it goes to the heart of things. At the moment, the Act does not specify how this should be done. And Elizabeth Gardner, the drafter behind the bill, said on the radio that we didn't have time to go into the detail of how these regimes work and to make the provision on the face of the bill. And so there are regulations making powers there which enable that provision to be set out. And that's Clause 32, I believe. So these enormous Henry VIII powers are being established to be delivered. And I deeply regret the gap in this bill, and I'm grateful to the mover of the amendment for enabling us to have this debate.
Order. I just remind the Honourable Member to keep to the issue that we're discussing, because if he or any other member doesn't, I'll take a view where I'll be take a much less lateral approach to these in future if members do go beyond the scope of what they really should be sticking to. And I say that gently and with the best intention. Thank you. Minister.
Thank you, Chair. I'll speak to this group of amendments as one, given that amendments 71 to 81 are consequential to new Clause 4. The purpose of the amendments is to create a new statutory body, the Assisted Dying Agency, which has the purpose of coordinating requests from people to be considered for assisted dying. The amendments provide for various functions and duties of the agency, including assigning a coordinating doctor and independent doctor to a person seeking assistance to end their own life. This agency would be responsible for accepting referrals, replacing registered medical practitioners with the roles of assigned coordinating doctor and assigned independent doctor, and receiving and recording declarations, statements and cancellations made by coordinating doctors, independent doctors and those receiving assistance under the bill. This would be a change from the current provisions in the bill, which place a number of those duties on the individual coordinating doctor and independent doctor. One effect of this proposed new clause is that a new agency would have to be established by the government, and if this amendment passed, we would have to work to assess how that might be possible in practice. I hope my brief remarks on this group are helpful to members of the committee in considering the bill and the amendments put forward. Thank you, Chair.
Kimberly Peter.
Thank you, Chair. I've nothing to add really other than to agree with the Honourable Member for East Wiltshire in that I don't think any of us on the committee are keen on the implementation of the assisted dying agency.
Just to move the amendment or to speak? Okay, well, I think Mr. Chair, I really do regret that we've had such a small debate on this enormous question of how on earth assisted dying would actually be delivered. We're leaving it to ministers subsequent to the passage of this bill to design this service. And the clear possibility is that it could be a private enterprise running this service. It might be an NHS service. The fact that this is unclear in the bill, I think, is shameful. But I'm grateful that we've had the opportunity to debate it, sort of. But I'm not going to press the amendments to a vote.
Is everyone content for the amendment to be withdrawn? Aye. Okay, thank you. The amendment withdrawn by leave. Amendment 276 to Clause 4 has already been debated with Amendment 278. I call Nice Shah to move the amendment formally. Amendment 276 to Clause 4 as on the amendment paper. The amendment is that the question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. No. Division. Lock. Everyone's happy? Lock the doors. Lock the doors.
Jack Abbott. Lewis Atkinson. No. Juliet Campbell. Aye. Bambos Charalambos. No. Daniel Francis. Aye. Sarah Green. No. Rachel Hopkins. No. Sir John Joseph. Aye. Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kip Malthouse.
No.
Sarah Olney. No. Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Savile Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastri Hurst.
No.
Dr Marie Tidwell.
No.
Sean Woodcock.
Aye.
The ayes were 7, the noes were 14, so the noes have it, the noes have it. Unlock. We now come to Amendment 345 to Clause 4 in the name of Anna Dixon, with which it would be convenient to consider Amendments 288, 297, 395, 295, 300, 302 and a new Clause 19. I call Sean Woodcock to move Amendment 345.
Thank you very much, Chair. Stand to move Amendment 345, tabled by the Honourable Member for Lee, whose record in this area was referred to in my earlier remarks. This amendment would ensure that medical practitioners record and document preliminary discussions with a patient about assisted dying and provide the patient with that information. I welcome the amendments from the bill sponsor to make reports of the first and second doctor's assessments, the safeguard patients and the process. It's important that we have transparency and clarity over such weighty decisions. Several people raised the importance of good documentation in their written evidence, and these amendments meet those concerns. Therefore, I assume not including a record of the preliminary discussion is merely an oversight by the bill sponsor. This amendment seeks to do what the Honourable Member for Spencer Valley's later ones do, protect patients and doctors by making records of the discussions. Professor Alan House, in his written evidence TIAB 55, suggested that it should be required, as it is in all other areas of medical practice, that specific written records are kept of this assessment and of procedures followed to end life, not just the substances used. The written record to be included in the person's medical record so that it is available to the medical examiner. Records also to be available at appraisal to enable assessment of the quality of the process.
Would there have been right?
Of course.
Thank you for giving and thank you for his comments. Would he just take note of my new clause 19, which is in this grouping, which does say that the preliminary discussion does have to be recorded?
Very grateful for that. I mean, it goes to the heart of my next question, really. Why would we record and document later conversations, but not the initial one? That conversation could be one where coercion takes place, and without a record of it happening, patients and doctors are at risk. So we've acknowledged that patients can be influenced by their doctors, whether consciously or unconsciously. We've also noted how certain groups lack trust in the healthcare system. Dr. Jamila Hussain, in her written evidence, TIAB 252, explained that the various inequalities faced by certain communities contribute to mistrust in health and social care services, that minority patients frequently express fear of having their lives shortened by healthcare providers, especially at the end of life, with medications such as morphine and midazolam. In situations where patients are uncertain or lack trust in medical professionals, a record of initial conversation is important to protect everyone involved. As Professor House stated, documenting the process and making records is common medical practice, so why would we differ here? We must protect patients and doctors, and making clear records at every stage of the process contributes to that, Chair.
Thank you. Amendment 345 to clause 4, as on the amendment paper, the question is that the amendment be made. Minister.
Thank you.
Sorry, beg your pardon, Nashar. I beg your pardon, Nashar.
Thank you, Chair. I'd like to speak to amendments 288 and 295 in the name of the honourable member, my honourable friend from York Central. I want to propose these two amendments, 288 and 295, both tabled by the honourable friend for York Central. Both of these amendments improve the quality of records kept about people applying for assisted dying. The aim of that is to make parliamentary and public scrutiny of the system easier and better. The first of these amendments is number 288. At the end of clause 4, page 2, line 36, it would insert a new subclause reading, all efforts to dissuade the person from ending their own life must be recorded in the clinical records and subsequently made available to the medical examiner. This recognises that a doctor may follow existing guidelines and seek to dissuade the person from ending their life. It ensures that such efforts are recorded to improve understanding of the bill and its interaction with suicide prevention. As Professor Alan House noted in his written evidence, the National Institute for Health and Care Excellence guidelines apply in other areas where it is important to explore thoughts about life not being worth living. After an episode of self-harm or in instances of suicidal thoughts, the medical professionals will explore current and recent personal and social circumstances, recent adversities and psychological state, beyond merely assessing the mental capacity and the presence of severe mental illness. In line with this suicide prevention strategy, a doctor may feel the need to dissuade the person from ending their life. A doctor would explore these psychosocial factors and seek to dissuade the person from ending their life. We know, Chair, that suicidal thoughts, depression, are particularly common among terminally ill people. Dr. Annabel Price, a member of a faculty of liaison psychiatry at the Royal College of Psychiatrists, gave oral evidence citing that among people who need palliative care at the end of life, 20% will have diagnosable depression, around 10% will have a wish to hasten death, and around 4% will have a more persistent wish to hasten death. Those who had a wish to hasten death were 18 times more likely to also feel suicidal. Terminally ill people are therefore at particular risk, and it is vital that the bill does not diminish wider suicide prevention strategies. This amendment, Chair, will record these instances where the medical practitioner may try to dissuade the person from ending their life. Some doctors may take the view of Professor Alan House, who said in his written evidence that a statement about wanting to end one's life cannot be simply taken as the result of a straightforward, rational decision to choose one type of end-of-life care over others. Furthermore, this amendment will also address some of the concerns about unconscious bias. Recording efforts to dissuade the person from ending their life would show when doctors assume a person should have had an assisted death and when others would not. Fazila Khadi of Disability Rights UK spoke about this in her oral evidence. What she said was, "We often find that doctors, because they cannot treat or cure us, do devalue our lives. We have had disabled people who have actually had it suggested to them or their families that their lives are expendable, when actually those people have got a lot of years to give." Providing records of a doctor's efforts to dissuade the person from ending their life will address some of these concerns. It will ensure there can be a more meaningful review of the impact of the bill on different groups, so that the right to die does not become a duty to die. In conclusion, this particular amendment serves to strengthen the safeguards in the bill by ensuring transparency and accountability in doctor-patient discussions, by requiring documentation of efforts to dissuade individuals from ending their lives. We would lessen the impact of the bill on wider suicide prevention strategies and provide evidence for meaningful review at a later date. Moving on to the amendment 295, again tabled by my honourable friend from York Central. This amendment, Chair, is about enabling public and parliamentary scrutiny of the assisted dying system. It will ensure that if this bill passes, there are good records of all applications for assisted dying and making sure they are readily available to the medical examiner. Some honourable members will know exactly what the medical examiner does. I will note for the record that this is a newly created public office in operation since 2024. The task of the medical examiner is to examine any deaths within the context of healthcare, whether NHS or private, that are not being examined by a coroner. In light of the magnitude of the decision being made, it is important for records to reflect this. It is equally important that those who will depend on the evidence are able to access the same evidence on which the coordinating doctor made their determinations. Therefore, it is essential that the basis of the decision-making is accurately recorded, along with the evidence from other practitioners. If, for instance, palliative care specialists, a clinical consultant and a psychiatrist or psychologist have been consulted, evidence of what they did and said must be readily available. It is essential that it sits with the record of the coordinating doctor. This information must be of use for the medical examiner to be able to come to their determination with all the evidence before them. It is also vital for the reporting mechanisms to be deployed for the process by which the Chief Medical Officer compiles their report. That is ultimately for which Parliament will be able to provide scrutiny for. Both of these amendments, Chair, greatly improve the quality of records that are kept concerning assisted dying. And if I recall correctly, the role of a medical examiner was brought into legislation following Shipman, and it was about tidying up and tightening the records that we kept, because clearly we had lessons to learn from then. We also, when we've heard evidence from other jurisdictions, there have been some jurisdictions, Chair, who have had good medical records, especially when it speaks to people who are potentially coerced. You know, in one jurisdiction we had somebody who said they'd never experienced felt a burden. In other, there were many more that said they felt a burden. And again, if we keep these records and we understand that these conversations have been had, then ultimately services will continuously need improving, no doubt. And should this bill become law, then these records would form part of that data collection that we could then effectively rely on for service improvements, for parliamentarians, etc. So it does speak to not just the actual bill itself, but going forward to ensure that this bill remains to continue to do what it intended to do. These amendments improve the quality and when it concerns the assisted dying. That in turn will make it far easier for us in Parliament and for our constituents and for the media to find out what is happening with any assisted dying system. We believe in this country in open justice and in open government. Assisted dying is much too important a matter to be allowed to operate without strong scrutiny by the press, the public and ourselves in Parliament. Therefore, I urge honourable members to vote for both these amendments. Thank you, Chair.
Thank you. Sir John Joseph.
Thank you, Chair. I'll just stand up to talk about this amendment, in support of this amendment. In my view, the documentation in our healthcare system is a very, very important matter, and this helps us to share good practices and learn from mistakes. Currently, the secondary care or primary care or nursing homes, the quality and safety of our patients is monitored by Care Quality Commission, who use documentation, the clinical documentation, as a key area where they carry out their process of monitoring those quality and safety. So I think it is important that any conversation with patients by the doctor or any medical professional or multidisciplinary team should be documented clearly. That will help safeguard our patients. Thank you.
Minister.
Thank you. This series of amendments relates to the various discussions and assessments that registered medical practitioners, coordinating doctors and independent doctors will have with individuals seeking assistance to end their life in accordance with the bill. In particular, they seek to amend the requirement for recording information about those discussions. As I've done throughout, I'll limit my remarks to comments on legal and practical impacts of amendments. In executing our duty to ensure the legislation, if passed, is legally robust and workable, the Government has worked with the member for Spen Valley on amendments to this bill, including new clause 19 in this group. Amendment 345 would require the registered medical practitioner, following a preliminary discussion with a person, to record and document the discussion and any information provided to the patient in that patient's medical records, and also require them to provide a copy to the patient. Amendment 288 adds an additional requirement on the registered medical practitioner who conducts an initial discussion with a person on the subject of an assisted death to record all efforts to dissuade a person from ending their own life in the person's medical records, and subsequently make those records available to the medical examiner. As drafted, it is not clear if the wording "all efforts" is intended to include efforts made by the registered medical practitioner alone, or to include efforts made by others, which could be reported to the registered medical practitioner. Further clarity would be needed to establish the practical implications of this amendment. The amendment also does not require this information to be recorded at a specific time. I would also note that operationally, medical examiners are not involved in scrutinising all deaths. Some deaths are investigated by coroners. Clause 29 will consider inquests and death certification in relation to assisted death. 297 requires a full written transcript to be produced for any consultations that occur as part of the first assessment undertaken by the coordinating doctor. This would potentially add some operability challenges, and if passed, we would want to explore those further. For example, there could be situations where the person seeking assistance does not want there to be a written transcript. Further clarity is also required as to whether this amendment intends to only capture consultations between the coordinating doctor and the patient, or whether it also intends to capture conversations with relevant persons other than the person seeking an assisted death. I'll now turn to 295. As the bill stands, if having carried out the first assessment, the coordinating doctor is satisfied that the person being assessed has met all requirements in clause 7.2, the coordinating doctor must A. make a statement to that effect in the form of Schedule 2 and sign and date it, B. provide the person who is assessed with a copy of the statement, and C. refer that person as soon as practicable to another registered medical practitioner who is able and willing to carry out the second assessment. This amendment seeks to add an additional requirement for the coordinating doctor to collate all evidence provided regarding the condition of the patient in a document to be provided to the medical examiner and the chief medical officer after the person has received assistance to die in accordance with the bill. This aims to ensure that the documentation will be available when required by the medical examiner. Sorry, did my honourable friend want
Yes, I thank the Minister for giving way. I just want to understand, when he referred to, just a few sentences ago, that if the patient doesn't want to keep a written record, how does that fare if there is potentially an issue of negligence later? Is it not a requirement on every NHS service that we provide, especially when it... So, for example, if it was kidneys, we were giving kidneys and we would need an independent assessor, those details would have to be kept. I'm just a bit confused. I wonder if the Minister might comment on that.
I thank her for that intervention. I think the challenge that we found around the amendment is that it's not entirely clear what would happen if the person were to expressly say that they didn't want to have a written statement. And so I think having not that eventuality is not baked into the bill as it's currently drafted. So I think it would require a lot of thinking through about again, we're sort of back to the law of unintended consequences. What impact would this amendment have in certain circumstances if, for example, somebody were to expressly say that they didn't want a written requirement? I think that's the question about the impact of the assessment is not clear. Of the amendment, sorry. Is not clear.
Thank the Minister. Perhaps the Minister could help me further understand. If that is an issue, then my understanding is, being new to this bill committee, if there are things that it's not because it's poorly drafted, it's because the outcome isn't clear. So can the government not then clarify that in wash-up stages or when the bill comes to third reading, report stage or third reading? Can the government, because there's been no, from the government I've heard nothing or any of the amendments that they could actually, in essence, even if they were supportive, that they would then go away and look at them. There's none of that conversation coming from government. Perhaps you could comment on that.
Yeah, I thank her for that intervention. As she knows, there'll be an impact assessment on the bill once it's cleared its committee stage. So if this amendment were to pass, then clearly the impact assessment the government carries out would be based on the bill as it's cleared committee stage. So as things stand, I can't tell her what the impact of this amendment would be, because the thinking through the eventuality of it passing and what the impact might be and all of the different angles, including, for example, if somebody were to expressly say they didn't want a written transcript, that hasn't been thought through in terms of its overall consequence. So that's where we stand on it. I'll turn now to Amendment 295. As the bill stands, if, having carried out the first assessment, the coordinating doctor is satisfied that the person being assessed has met all requirements in Clause 7.2, the coordinating doctor must A. make a statement to that effect in the form of Schedule 2 and sign and date it, provide the person who was assessed with a copy of the statement, and C. refer that person as soon as practicable. I'm terribly sorry, I've actually read that. And I've gone through to the relevant chief medical officer after the person has received assistance to die in accordance with the bill. This aims to ensure that this documentation will be available when required by the medical examiner. 300 requires there to be a full written transcript of the second assessment as the record of the conversation. This goes further than the current requirement in the bill placed on the independent doctor, which requires a statement only as contained in the form in Schedule 3 to the bill. As with Amendment 297, further clarity is required as to whether this amendment is intended to only cover consultations with the patient or whether conversations with other individuals should also be transcribed. 302 requires the independent doctor to provide details of the way in which the second assessment was conducted, alongside a written transcript of any consultation to the relevant chief medical officer and the person's GP. Further to this...
I thank the Minister, he's been very generous with his time. I just want to understand further to that. I genuinely, the idea that somebody might say they don't want a written transcript when everybody in our country who uses the NHS service has a written medical record. So why in this instance is the government of the view that we should be straying from normal practice?
Well, I thank her for that. I think this reflects the fact, as this committee has agreed, we're in uncharted territory on a whole range of issues here. So I think it's best to think through the implications of every amendment, and if it were to pass, every clause of the bill has to be assessed for its potential impact. So You know, there are other questions around the amendment, which I also suggested in my notes. So we said there's also a need to, does the amendment intend to only capture consultations between the coordinating doctor and the patient, or whether it also intends to capture conversations with relevant persons other than the person seeking an assisted death? That's also not clear from the amendment. So there's the amendment, as what I'm basically saying to my honourable friend is, this amendment poses more questions than it answers.
Would you give way on that point? Sorry, John.
That's okay.
I think you were first.
I thank you for giving way. My understanding would be, and I might be wrong, is that a patient could presumably ask for access to their medical records at any point. So on the basis that new clause 19 requires the doctor to record a thorough discussion, presumably if a patient wanted to see that recording of the discussion, they would be able to access that.
I agree with my honourable friend on that point, and officials have worked with her, as I stated at the start of my comments, on new clause 19, which I do think goes a long way to clearing up many of the points that have been raised, including hers.
Order. Minister, thank you. Right. The Minister is responding to questions, and members are standing up when he's in the middle of responding to a particular question. So can we wait until the Minister responds to the individual question before the members stand up and ask a question on a question, please? Minister.
Thank you, Chair, and I think my honourable friend was next. I've answered the question from my honourable friend for Spen Valley, and I'm happy to take another intervention.
The question that I wanted to pose was that throughout this whole discussion and debate, we've consistently spoken about things that happen normally within medical practice. But on this amendment, we're going away from ordinary practice. Could the Minister explain to me why would we do that?
I thank my honourable friend for that intervention. As I've set out, the officials have looked at this amendment and raised a couple of flags or questions about it. One is what we've discussed about the transcript, and the other is it's not clear whether other people should be included in the consultation. So I don't think it's so much about departing from current or common practice, it's much more about the questions that the amendment raises. As always, the government is neutral. If this committee sees fit to pass this amendment, then the government will work to ensure that it's, well, if in the eventuality that it's workable, we hope that it would be workable, we trust that it would be workable in the wisdom of the committee if it's passed. But as things stand, it raises a number of questions, and that's really all I'm flagging.
I thank the Minister for he's been generous with his time. I just want to really understand this, because I'm even more confused now. Because originally the Minister suggested that there might be a patient who doesn't want a transcript, whereas new clause 19, in response to the member for Spen Valley's question, in new clause 19, people have access to their written records. So that appears to be a bit of a contradiction. I just want to nail down which one is it going to be. So if a patient doesn't want a written record, then we wouldn't have a written record to access. So that contradicts that response. So I just want to really understand what is it that the Minister is saying or suggesting.
So the government has worked with the sponsor on new clause 19. The government's view is that if the committee accepts new clause 19, then that clause provides the level of robustness and resilience that the system requires. The amendment that my honourable friend is talking about, the government is not convinced that that amendment on its own would provide the level of robustness and resilience that we'd be looking for. So I think as things stand, the choice has been made to work with the honourable member on new clause 19, and we're satisfied that that would provide us with the operational integrity that we need. Amendment 302 requires the independent doctor to provide details of the way in which the second assessment was conducted, alongside a written transcript of any consultation to the relevant chief medical officer and the person's GP. Further to this, the independent doctor would be required to maintain a copy of this record to provide to the relevant medical examiner. Turning now to new clause 19, as mentioned, in executing our duties to ensure the legislation, if passed, is legally robust and workable, the government has worked with the member for Spen Valley on new clause 19. This new clause requires a practitioner to include a record of a preliminary discussion having taken place under clause 4. the record of the preliminary discussion must be included in the person's medical records. Where the medical practitioner is a member of the person's GP practice, they must make such a record in the person's medical records as soon as practicable. Where the medical practitioner is not a member of the person's GP practice, they must, as soon as practicable, provide a written record of the preliminary discussion to a medical practitioner at the person's GP practice, who is then required by this section to include it in the person's medical records as soon as practicable. The committee may wish to note that Amendment 424 proposes to add a definition of the preliminary discussion to the bill, which would make clear what discussion medical practitioners would be required by law to record. Chair, that concludes my remarks on amendments proposed in this group, and I thank the committee for its attention.
Thank you. Kimberly, Peter.
Thank you, Chair. I rise to speak briefly to my new clause 19, which I'll be moving this afternoon, which, as has been discussed, refers to the recording of the preliminary discussion. Chair, this new clause requires the practitioner to include in the person in question's medical records a record of a preliminary discussion under clause 4. As we've said, the initial discussion with the patient is very important, and as such it should be recorded in their records. I hope colleagues agree and will support this amendment.
Sean Woodcock.
To move forward.
Yeah, withdraw.
No, to move forward.
Just press throughout. Okay, right. In that case, division. Amendment 345 proposed to clause 4 as on the amendment paper. The question is that the amendment be made. As many of their opinion say aye. Aye. Contrary, no. No. Division. Lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell. Bambos Charlambos.
No.
Daniel Francis.
Aye.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Saville-Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastry-Hurst.
No.
Dr Marie Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 14, so the noes have it, the noes have it. Unlock. Amendment 413 to clause 4 has already been debated with Amendment 414. I understand that the Honourable Lady does not wish to press her amendment to a vision. Is that correct? Is that Right. Amendment 425 to clause 4 has already been debated with Amendment 425. I call Danny Kruger to move the amendment formally.
Move formally.
Amendment 425 to clause 4 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. And of the contrary, no. No. Division. Everyone happy? Lock the doors.
Jack Abbott. No. Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charlambos.
No.
Daniel Francis.
Aye.
Sarah Green.
No.
Rachel Hopkins.
No.
Surgeon Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Ledbeater.
No.
Kip Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer?
No.
Rebecca Paul?
Aye.
Jake Richards?
No.
Sarah Sackman?
No.
Liz Saville-Roberts? Naz Shah?
Aye.
Dr Neil Shastry-Hurst?
No.
Dr Marie Tidball?
No.
Sean Woodcock?
Aye.
The ayes were 8, the noes were 14, so the noes have it. The noes have it. Unlocked. Order. I intend to suspend the sitting for 15 minutes. That will be 10 to. Order, order. We now come to Amendment 412 to Clause 4 in the name of Danny Kruger, with which it will be convenient to consider Amendments 341, 338, 287 and new Clause 13. I call Danny Kruger to move Amendment 412, but before I do, I just want to remind people to keep in scope, to make sure that the points being raised are relevant and they are not repetitive, or I will intervene. Danny Kruger.
Thank you very much, Mr. Chairman. And this is a very important group of amendments. I'm going to speak to my own 412, to the Amendment 341 in the name of my honourable friend for Sleaford and North Hykeham, to 338 and new Clause 13 in the name of the gentleman for Bexley, and the Amendment 287 in the name of the honourable member for York Central. All of these in their different ways are relevant to the duty to refer that a doctor who doesn't want to advise a patient on assisted dying should be obliged to send them to somebody who is. And in different ways we each seek to provide more protections for those medical professionals. There are two main reasons why doctors may not want the obligation to refer that is currently in the bill. The first is the essential point that this is not a healthcare treatment as traditionally understood. Assisted dying does not address the conditions, it doesn't treat the illness, it only treats the symptoms in the sense that it obliterates the existence of the patient. Like the advert for bleach, it kills all known germs, it kills every experience that the patient has or could have. This is not part of the range of treatments that a doctor should have to offer, as subsection 4, subsection 1 makes clear. And this goes similarly to the question of referring to somebody who can. I suggest that the act of referring is an act of endorsement, just as offering the intervention itself is an act of endorsement. And Dr. Green from the BMA made clear in oral evidence that the BMA doesn't like the word refer, as it implies assent to the option that's being offered. And indeed, I think the Honourable Lady herself, in conversation with Dr. Green in the oral evidence session, accepted that the word refer wasn't quite right, so I think she put it, because refer does have this particular implication and expectation of a form of endorsement. And we've had this from multiple witnesses, written and oral, to the committee, particularly from Muslim medical professionals and their trade body, which, and particularly those representing pharmacists, expressed significant concern that they might find themselves included in the scope, including in the definition of medical practitioner. The same goes for the Association of Anaesthetists, made the same concern. The Royal College of Nurses worried as well. So there's a range of professional bodies, representative organisations, that share my concern that imposing a duty to refer, an obligation to assist somebody to have an assisted death by finding them a doctor who will conduct the preliminary discussion, is itself a breach of their rights and their rights of conscience. The second reason, Mr. Chairman, follows from this. Doctors may reasonably conclude that being in a position to help with assisted dying is to put themselves in a totally different relationship with their patients. And I think this is why the BMA is so unhappy, and they've asked for it to be removed. And they have an alternative, which some of these amendments speak to. They say, we urge the committee to remove the referral requirement and instead make it clear that the doctor's duty is to direct patients to where they can obtain information. So this is the amendment, I think it's 341, is it, in the name of the member for Sleaford. And they suggest that there should be an official body set up to provide information and advice to patients, to which patients could be referred or directed, or they could self-refer. So my preference would be not to have any obligation on doctors to make any kind of referral, but I respect the aspiration of this amendment, which would be to ensure that there was an independent body that patients could seek out themselves, or that patients could be advised of, which would give advice rather than being expected to refer to a doctor who would help facilitate the assisted death. The Royal College of General Practitioners is also unhappy about the provision. They also suggest that instead of expecting doctors to refer directly to a medical practitioner who is willing and able to conduct the discussion as per the bill, the doctor's duty would simply be to direct patients to an official service where they can obtain objective and accurate information. So I think that we should pay heed to the advice of the professionals in this way. Now, as ever, I like to refer to the experience of foreign jurisdictions because we are constantly being told that this bill is the safest in the world. But none of the legislation in Australia or New Zealand or the legislation currently going through in the Isle of Man puts this obligation to refer on to doctors. Victoria and South Australia say that a doctor, I quote, has the right to refuse, not just to, quote, to participate in the request and assistance process, but they can also refuse to give information about voluntary assisted dying. So there's no duty to refer, not even a duty to provide information. So, Mr. Chairman, let me conclude with an observation that was submitted to us by Dr. David Randall, who's a consultant nephrologist. He said in written evidence, I think this was very telling, he said, I would not be willing to act in accordance with section 4.5 of the bill. I'm a doctor in good standing with the GMC, who has always striven to provide the highest standards of care to patients. Passage of this bill would place my practice in direct opposition to the criminal law. So he talks about moral injury, and I think that's a very, very important principle. We have an obligation to protect the conscience and the human rights of medical professionals, and whether this is taking place within the NHS or outside, we're still unclear on that question. Nevertheless, the obligation to refer that's currently in the bill, I think it would impose a direct breach of their rights and impose a moral injury on doctors. And my preference is that we remove subclause 4.5 altogether, be consistent with the Abortion Act, with other and similar legislation in other countries around assisted dying. If we're not prepared to do that, we can at least restrict and the obligation and provide more protections as per the amendments in the names of other honourable members. Thank you.
Thank you. Amendment 412 to clause 4. As on the amendment paper, the question is that the amendment be made. Rebecca Ball.
Thank you, Chair. I wish to speak in support of Johnson Amendment 341, and this amendment would provide that a registered medical practitioner who is unable or unwilling to have the preliminary discussion with a person must provide information to the person about where they can have that discussion, but this need not take the form of a referral. One of the messages we heard loud and clear during the evidence sessions is that medical practitioners do not wish to be under an obligation to refer a patient to another registered medical practitioner under this bill. Referral has a very specific meaning in medicine, and it is this word and the corresponding action required of it that gives many doctors an issue. A referral puts a patient on a pathway, whereas the provision of information merely indicates where such a pathway can be found. During oral evidence, Dr. Green said, and I quote, "The word referral to a doctor means writing a letter or communicating with another doctor to see. But some doctors would find themselves not able to do that. For that reason, we believe that there should be an information service for the doctor to direct to." So, we are all well aware that assisted dying is a complex issue and a matter of conscience for many. It's therefore important that we respect the personal views of medical practitioners. One of the points I've made several times through these proceedings is that assisted dying does not just impact the patient, it involves other people participating and supporting. Some medical practitioners will be comfortable with this, but many others won't. It's therefore vitally important that we recognise their rights and needs when formulating this law, not just the patient's. If a doctor does not want to refer a patient for whatever reason, they should not have to. Their legal responsibility should be limited to directing the patient to where they can find the relevant information they need at most. And they should have no further obligation. The current clause 4, subsection 5, would place many doctors in an impossible position. Referral would mean writing a letter to or putting the patient in touch with another doctor. For many, this is tantamount to involvement with assisted dying and not something they are comfortable with. Dr. David Randall, a consultant nephrologist at the Royal London Hospital and honorary senior lecturer at Queen Mary University of London, says in written evidence, and I quote, "The Terminally Ill Adults End of Life Act will cause significant damage to the healthcare workforce by imposing a duty of effective referral on medical practitioners who object to direct involvement, an obligation which will drive some from the profession and impose moral injury on those who remain. The BMA has also specifically raised concerns about Clause 4, subsection 5, and have requested in their written evidence that, and I quote, "We urge the committee to remove the referral requirement and instead make it clear that the doctor's duty is to direct patients to where they can obtain information and have that discussion. We suggest elsewhere that this should be an official body set up to provide individual information and advice to patients, to which patients could be referred or directed to or could self-refer." The Royal College of GPs are also unhappy about this provision, saying in written evidence, and I quote, "In order to further protect those medical practitioners who are unwilling to conduct the preliminary discussion, we would support an amendment to Clause 4, subsection 5, to make it clear that instead of expecting them to refer directly to a medical practitioner who is willing and able to conduct that discussion, the doctor's duty would be to direct patients to an official service where they can obtain objective and accurate information and have a preliminary discussion." It should be noted that none of the legislation in Australia or New Zealand or the legislation currently going through the Isle of Man has a duty to refer. Victoria and South Australia, for instance, say a doctor has the right to refuse, not just to participate in the request and assistance process, but can also refuse to give information about voluntary assisted dying. There is no duty to refer in either law. In American states, doctors are generally not obliged to give information, let alone make referrals. It's also relevant to note that there is no statutory duty to refer under the Abortion Act, and indeed there is no duty to signpost to information, although BMA GMC guidance requires a medical practitioner to ensure that a patient has the relevant information that they require, and rightly so. I therefore support Amendment 341, which seeks to remove the requirement to refer and instead replaces it with an obligation to direct them to where they can obtain information and have the preliminary discussion. This amendment is in line with the written evidence received, so I do hope some of the committee members will join me in supporting this. Thank you.
Did you give way? Have I missed it?
I will give way if the chair will allow.
Just got in there before she finished. I thank her for her comments, and she's made some really important points there. I just want to reassure her and possibly other members of the committee, I am minded to support Amendment 341.
Well, I thank the Honourable Lady for that intervention, which I most welcome.
Thank you. Lewis Atkinson.
Thank you, Chair. I will be brief. I'm very, very pleased to hear my Honourable friend from Spen Valley confirm she will is minded to support 341. I think it's incumbent on all of us, but perhaps particularly those in favour of this bill, to place on the record our appreciation and recognition that there are many people that work in our health services that do hold strongly held religious beliefs or beliefs of conscience, however they're motivated, and that the law, as currently happens for a range of other procedures and medical interventions, has to allow them scope to continue to practice. And they make a really valuable contribution to our health service and our national life, and there's nothing that we should do or do in this that impinges on that. There is existing very strong guidance from the General Medical Council about personal belief, and that applies, as the Honourable Lady alluded to the Abortion Act, to the Human Embryology and Fertilisation Act, to the Female Genital Mutilation Act, and any other such procedures. And it's not for any of us to guess, to second guess someone's conscience of what instances they should be. Yes, I will.
Just to, perhaps you could comment that female genital mutilation, there is nothing in religion or anybody's religion. It's not a religious belief, it is a cultural, and it is actually child abuse. That's what it is. There's no ifs, no buts in that one.
I don't disagree with the Honourable Lady. What I generally just say is that the GMC guidance specifically references that act in the GMC guidance. So that's what I was referring to. So I am very pleased to see Amendment 341, which I believe brings this legislation in line with that GMC guidance, ensuring that people absolutely, this is not a licence for people to be left without access to care. The GMC is very clear, as the Honourable Lady said, that people must be given sufficient information and empowered to seek the options and information that they need, and therefore I'm pleased to be supporting that amendment. Thank you.
Daniel Francis.
Thank you, Chair. Just under chairmanship. I note the comments from my honourable friend from Spen Valley that she's minded to accept Amendment 341. I will, however, still briefly speak to 338 and new clause 13, which stand in my name. The British Medical Association have said that they strongly urge MPs to support these amendments, which would remove the referral requirement in relation to preliminary discussion and establish an official body to provide factual information to patients about the range of options available to them. And as the member for East Wiltshire has already commented on, Dr Green needs oral evidence said to us that the provision of information will be very useful because in a situation where a doctor was unwilling to have an initial discussion with the patient, it would provide a way for the patient to get that information that was in no way obstructive. And he went on to say, I do not believe that it's ever appropriate for a doctor to recommend that a patient goes through an assisted dying process, and he particularly referred that the word referral to a doctor means writing a letter or communicating with another doctor to see that some doctors would find themselves not able to do that. For that reason, we believe that there should be an information service for the doctor to direct to. And the BMA's position is it's analogous to doctors' professional and legal obligations regarding abortion, and it's consistent with the bill's inclusion of clause 23 of a right to refuse to carry out activities directly related to assisted dying for any reason. And they say in tandem, we believe creating an official body to provide individual information and advice to patients to which doctors could direct rather than refer patients would ensure the doctor's views are respected, whilst also crucially ensuring that patients can easily access the information and support they need. Currently, whilst the bill acknowledges the need for accurate, impartial information and advice for patients, it gives no indication of how this might be delivered. Generic published information would not be sufficient. Patients would need individual advice, guidance and support so they can make informed decisions, and an independent information service could meet that need. As has been referred to by the member for Reigate, the Royal College of GPs have also said that the BMA referred to the word refer, referring to a colleague for those who do not want to do it. We agree that signposting is a better process. And they went on to say, similar to other services such as a termination of pregnancy, we think that the best option will probably be that the GP could signpost an information service, such as something like what the BMA suggested. They would not have to do anything more than that, and they would not withhold any information from the patient. So, therefore, I do stand to move the amendments in my name, Chair, which are 338 and new clause 13.
Thank you. Rochelle.
Thank you, Chair. It's long to follow my honourable friend. So I'm right to speak to Amendment 287, Chair, from my tabled by my honourable friend from York Central. This amendment, what this would do is change clause 4, page 2 from line 34. Currently, that part of the bill reads, a registered medical practitioner who is unwilling or unable to conduct a preliminary discussion mentioned under subsection 3 must, if requested by the person to do so, refer them to another registered medical practitioner whom the first practitioner believes is willing and able to conduct that discussion. If this amendment was adopted, it would read instead, a registered medical practitioner who is unwilling or unable to conduct the preliminary discussion mentioned under subsection 3 must, if requested by the person to do so, refer them to another registered medical practitioner who is qualified to undertake such a preliminary discussion and set out palliative medicine options to provide the patient with the appropriate end-of-life care, including referring them to palliative medicine experts. Put simply, this amendment would mean that if a doctor met with a patient with a severe illness who might die within 6 months, but was unwilling themselves to have an initial discussion on assisted dying, they would still have to refer them on to a doctor who was willing to have that discussion. The patient's decision to explore assisted dying will not be obstructed. The main change that it would make would be that this doctor will now have to discuss palliative care options with the patient. That is surely a measure which would increase the welfare of the patient. Let us think about the kind of patient who can apply for assisted dying. They must have a diagnosis of a serious illness and a prognosis that they are likely to die within 6 months. The bill's supporters have said many times that they are worried about any changes which will reduce the autonomy of people seeking assisted death. This amendment quite obviously does not in any way reduce people's autonomy. It also does not in any way place an unreasonable burden upon doctors. If a patient has a diagnosis of a serious illness, and if they have themselves asked for a conversation on assisted dying, then it surely must be good practice for that doctor to discuss palliative care options. It is also only good practice for that one of those options would be for the doctor, if the patient wishes, to refer the patient to a palliative medicine specialist who is more able to talk about such options. That means that this amendment would not place any undue burden on either the doctor or the patient. The doctor ought to be offering such advice on palliative care. The patient may or may not decide to take the doctor's advice on palliative care, but they have had it, and the patient may well benefit from having had advice on palliative care. I think I can, given the conversations we've had this morning, I think I can foretell one objection to this amendment, that since good doctors will do this anyway, then it is unnecessary to have a provision on the face of the bill or of the law to do it. But this seems to me to be a very weak objection. Let us be honest, the doctors that we have in this country are of extremely high quality. They are dedicated, skilled, compassionate men and women. We are lucky to have them. But we cannot say that every doctor participating in all the processes they currently do always follow best practice. Similarly, we cannot say that in any assisted dying process, doctors will always automatically follow best practice. People make mistakes. That includes people who are highly trained and extremely compassionate. I would be astonished if we could find a doctor who said they had always got everything right. So as lawmakers, we have to guard against the fact that even some of our most admired professionals can and sometimes will make mistakes. One way that we will guard against that is to set our duties out which they have to follow. This amendment does just that. I hope we will not hear the objection that we have heard to many good amendments, that it will somehow make the bill more dangerous by adding complications. This simply adds a small step, a doctor having a duty to give palliative care advice to a patient with a diagnosis of serious illness. It surely cannot be the case that this bill is so lacking in robustness that such a small change would make it dangerous. In summary, this amendment is a sensible change. It would not in any way block the ability of adults who meet the conditions set out by this bill to explore assisted dying. Neither would it place any burden at all upon doctors. It would simply lay upon them a duty to follow what we can all surely agree is best practice. Instead, it would greatly improve the early access to palliative care advice for patients with diagnosis of serious illness. That would improve those patients' chances of receiving good palliative care. So therefore, I would urge honourable members to support this amendment. Thank you, Chair.
Thank you. Minister.
Thank you, Chair. Amendment 412 seeks to remove the duty in clause 4, subsection 5, on a registered medical practitioner who is unwilling or unable to conduct the preliminary discussion to, upon request, refer the person to another practitioner whom the first practitioner believes is willing and able to conduct that discussion. Guidance for medical professionals requires that where a practitioner objects to performing a procedure, they must refer the patient to a practitioner who can meet their needs. Amendment 341 removes the duty on a registered medical practitioner who is unwilling or unable to conduct the preliminary discussion to, upon request, refer the person to another registered medical practitioner whom they believe is willing and able to conduct that discussion. The amendment requires the registered medical practitioner who is unwilling or unable to conduct the preliminary discussion with the person to instead ensure that that person is directed to where they can obtain information and have the preliminary discussion. Turning to new clause 13 and amendment 338. This new clause would introduce a requirement for the Secretary of State to create via regulations an independent information and referral service for individuals who are or may be eligible under the bill for assessing assisted dying services. The accompanying amendment, Amendment 338, requires a registered medical practitioner who is unwilling or unable to conduct the preliminary discussion to direct the person, upon that person's request, to another registered medical practitioner or to the information and referral service as set out in the new clause. The effect of this amendment is to remove the existing obligation in clause 4, subsection 5, for the registered medical practitioner to refer the person to another registered medical practitioner whom the first practitioner believes is willing and able to conduct the initial discussion. This amendment would make it more likely for a person seeking assistance to be referred to someone who is unwilling or unable to help. In addition, these amendments could carry an operational impact as the new service would need to be designed and brought into existence. Amendment 287 would mean that if the first practitioner is unable or unwilling to conduct the preliminary discussion, they must, upon request, refer the person to a registered medical practitioner who is qualified to undertake the preliminary discussion, and they must also set out palliative medicine options to provide the patient with appropriate end-of-life care, including referring the person to a palliative medicine expert. This amendment removes the existing duty in clause 4, subsection 5, to refer to a practitioner who the first practitioner believes is willing and able to conduct the preliminary discussion. As with previous amendments, this language could make it more likely for a person seeking assistance to be referred to someone who is unwilling or unable to help. It is not clear what qualified to undertake the preliminary discussion is intended to mean. In addition, the term palliative care expert is not a defined term. Palliative medicine is a designated speciality of the General Medical Council, the GMC, and a doctor can apply to be entered onto the GMC special register for this speciality, provided they have the specialist medical qualification, training or experience. I hope these observations are helpful and thank the committee for its attention. Thank you, Chair.
Thank you, Chair. I'll speak on 341, 338, 412 together, and I welcome the debate on these important amendments. Choice is one of the key tenets of the bill, primarily but not exclusively for terminally ill adults with a limited time to live. Choice is also very important for medical practitioners, and I'm very respectful of and acknowledge the importance of conscientious objection for doctors, and I believe when it comes to assisted dying they should also have choice. Indeed, the bill is written so that they can choose not to participate in the process for any reason. This is the BMA's view, and I agree with them. The BMA has a position of neutrality on assisted dying, and there are a range of views within medical professions, as there are within all groups of people. This is why I have adopted their position around an opt-in model for the purposes of the bill. Nevertheless, the process must remain patient-focused at all times, and that does mean enabling them to have a discussion on such an important matter. It would not be right to rely on online advice or even the best written material, best designed written materials. As we've already established, doctors are used to having sensitive and compassionate discussions with people who are terminally ill, and there can be no substitute for that. So while a doctor may not wish to participate themselves, and I fully respect that, they do still have a responsibility towards their patients, and that should include ensuring they can speak to a properly qualified medical practitioner at such a difficult time. But I understand that the BMA and others would not be comfortable with the word refer, which I understand has a special meaning within medical practice. GMC guidelines uses different language. They talk about where a doctor has a conscientious objection, they are advised that you must make sure that arrangements are made for another suitably qualified colleague to take over your role. The BMA's own guidance says patients must be able to see another doctor as appropriate, and it goes on that referral in these circumstances need not always be a formal procedure. However, it is not simply sufficient to tell the patient to seek a view elsewhere. I agree completely. The BMA supports Amendment 341, which says that a doctor must ensure that the person is directed to where they can obtain information and have the preliminary discussion. As such, I'm happy to support this amendment today, and if it were to need further adjustment, I'm very happy to consider alternatives based on existing best practice, and I would be very happy to meet with the Honourable Member for Sleaford and North Hykeham, who is of course herself a doctor, to discuss her thoughts and draw on her considerable medical experience. Thank you, Chair.
Danny Kruger.
I'm straight ready to this scrutiny.
Can I just get clarity? Did you wish to draw the amendment?
No, to withdraw that. I'll withdraw the amendment.
Do withdraw the amendment. Is everyone content for the amendment to be withdrawn? Aye. Those agreed? I say aye. No, agreed. Now move on to amendment 341 to clause 4, which has already been debated with amendment 412. I call Rebecca Paul to move the amendment formally. Amendment 341 to clause 4, as on the amendment paper, the question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. Amendment 338 to clause 4 has already been debated with amendment 412. I call Daniel Francis to move the amendment formally.
I'll withdraw it in 341.
Okay, is it agreed that the amendment be withdrawn? Aye. To the contrary? No. Thank you. Amendment 287 to clause 4 has already been debated with amendment 412. I call the... Can I call it a member to move formally? Would anyone wish to move this formally? No. Okay, in that case the amendment is withdrawn. We now come to Amendment 125 to Clause 4 in the name of Juliet Campbell, with which it will be convening to consider Amendment 126 and new Clause 7. I call Juliet Campbell to move Amendment 125.
I will speak to Amendment 125 and 126, which are linked to new Clause 7. And given the discussion that we have just had and that 341 has been moved, I will remove 125. However, Amendment 126 provides that any medical practitioner who wishes to provide assistance under the Act must have opted in to a register or a service for practitioners who are comfortable with providing care related to assisted dying. Now, in other conversations, the sponsor of the bill has said that the opt-in model is provided within the bill. The challenge is that it's not explicit in the bill, and I would like to see it explicit in the bill. So the BMA has written in their evidence that they would like to see an opt-in model. So they're quoting what their written evidence says. It says the bill should be based on an opt-in model so that only those doctors who positively choose to participate are able to do so. Doctors who opt in to provide the service should be able to choose what parts of the service they are willing to provide. For example, assessing eligibility and/or prescribing for eligible patients. And that an opt-in model is not explicit in the bill. But they urge the committee to make it explicit in the bill and that this opt-in arrangement is available to doctors. So the BMA is actually saying they want it explicit in the bill, and at the moment it is not. The Royal College of General Practitioners align with this viewpoint, and they too ask that an explicit opt-in system is completely necessary. And they state that they would like to see it in the bill. So it is my hope, Chair, that members of the committee will support this amendment, which I will push for division. Thank you.
Mr. Chair, I'm grateful, and I'm grateful to the Honourable Lady for her opening.
Order. Apologies. Amendment 125 to clause 4 as on the amendment paper. The question is that the amendment be made. Malthouse.
I'm grateful to you, Mr. Chair. Sorry for jumping the gun slightly. I'm afraid I'm going to disappoint the Honourable Lady by rising to oppose her amendments, although I understand why she's put them down. It was clear from the evidence of the BMA that they opposed the creation of a list of registered providers that is that she's proposing to create with these amendments, and they certainly their opposition and my opposition are based on 2 or 3. Yes, Bowman.
So at the beginning, thank you. Based on the fact that we agreed on 341, I would have removed 125. It's 126 that I'm proposing.
I understand, but the 126 also refers to the register of being maintained of appropriate medical practitioners. Of course, new clause 7 similarly creates and we're debating all of those three at the moment. And so I just wanted to explain why I oppose those three, and indeed, as do the BMA. First of all, as has been outlined in previous speeches, the bill does create an opt-in model. Effectively where people who want to be the coordinating doctor or indeed the second doctor have to opt in and be trained and therefore become accredited, and so by definition they are approved for that service. However, the bill does not envisage that the initial conversation is necessarily with the coordinating doctor, and it might well be the case that there are other medical personnel, practitioners, and we've talked a lot about semantics during this debate, who are presented with the situation where a desperate person, somebody who's been given some extremely bad news, wants to talk about their situation and what their options might be. And we hope and believe that training will spread throughout the NHS to those who want it. But nevertheless, we have to leave the option open that those people may not be accredited. They may need to pass someone by whatever means the bill decides, to a doctor who is and can act as the coordinating doctor, who's had the appropriate training and opted in. And I'm afraid this register doesn't allow for that. The second thing that it concerns me slightly is one of the things I think we do need to avoid, both for the benefit of the patient and for the growth of the system, is any kind of notion of doctor shopping, that there's a list of doctors that I can shop around and find. And I do worry slightly about that. My hope is that these conversations, which are necessarily private and sensitive, will take place in an environment of embrace and familiarity between doctor and patient. Now, we've talked a bit about whether doctors have to refer or provide information. Obviously, we've just adopted an amendment that seeks to set out how that will work. What I would oppose is the creation of a list that people can move up and down and pick somebody that they like the look of or that they think might be handy for them, for two reasons. First of all, because I'm not sure it's entirely reputable, but secondly, we've got to remember who we're dealing with here. These are dying people who we're talking about 6 months as a minimum, but actually they might only have 3 months, 2 months to go. And we need to, as I say, create a sense that this is something that will be provided to them in an environment that is familiar. They don't have to spend their time finding a doctor on a list with a number, ringing up the office saying, this is what I want to do, can I make an appointment? You know, there's a privacy aspect to it. And then the third objection that I have, to be honest with you, is one about privacy, not just of patient, but also of doctor. She will know that, unfortunately, there are, I don't know whether she thinks unfortunately, but I do, unfortunately, there are some people who object so strongly, for example, to abortion, that they are willing to go and protest outside clinics that provide that service. And this House has legislated to, if you like, balance the rights of those who want to avail themselves of that service and those who want to protest. And that has been a source of conflict. For there to be a public list of doctors who provide this service, I'm afraid, raises questions about doctors' privacy, about patient privacy, about access to that service. And I'm concerned about it from that point of view. So, yeah.
I thank the honourable member for giving way, and I hear what he's saying, and I get his point. I'm just trying to understand, and perhaps he can speak to it. We already have lists of specialists who provide. So when we have choose and book, for example, albeit it is a treatment, the NHS provides those lists of doctors. So why would this be any different?
Well, we don't have necessarily specific registers. People are members of professional bodies. And within those professional bodies, people become accredited because of their training. But a bit like the Minister referred earlier, there's no such thing as a sort of list of palliative care specialists. It's not defined in that way. And I do think that creating a list in this way will be, if the lady will give me a moment, Honourable Lady will give me a moment, would be, as I say, would present problems for privacy of doctor and patient as they go about what I hope we all acknowledge is a very sensitive and private process at the very end of someone's life. So, Mr. Chairman, I'll conclude at that point and say that, unfortunately, great respect to the Honourable Lady, I do oppose these amendments.
Minister.
Thank you. Given that amendments 125 and 126 are consequential to new clause 7, I shall speak to them as a whole and not in turn. The purpose of these amendments appears to be twofold. Firstly, the amendment seeks to restrict the role of medical practitioners who can hold an initial discussion to those who have completed training. This training would be specified by the Secretary of State in regulations and would make them eligible to be listed on the Register of Assisted Dying Medical Practitioners. For ease, I shall refer to this as the Register from now on. Secondly, the amendment seeks to apply the same principle to the coordinating or independent doctor. In addition, these amendments place a duty on the Secretary of State to make regulations that would create the Register to sit outside or alongside the current system of registration of medical practitioners and set out the training requirements to be eligible to be listed on the Register. Both sets of regulations are to be subject to the affirmative procedure. The Secretary of State must consult such persons as they consider appropriate before making them. The regulations making provision for the relevant training requirements must be laid within 6 months of the passing of this Act. The regulations establishing the Register must be laid within 12 months of the passing of this Act. Although the purpose of the amendments is clear, our assessment suggests that the drafting does not achieve the desired effect. According to the drafting, the Register would only include those doctors who have not undertaken the specified training or who have opted out of the assisted dying service. Additionally, the suggested time frame for laying regulations is unworkable given the need to work with regulators and the proposed duty to consult. There are also significant operability concerns regarding the creation of a new register for a subset of registered medical practitioners. I hope the committee has found these observations helpful, and I thank them for the attention.
Give him lead, Peter.
I have nothing to add, Chair.
Thank you. Right. For clarity on this particular one, Amendment 125 has not been pushed to a decision, as I understand, just took it, as you understand, by the Honourable Lady, which we'll come to. Just for clarity, Amendment 126 and new clause 7 will be decided in due course, so we will come back to that. And Amendment 126 is actually in clause 23, so that's further down the line. So, if the Honourable Lady is withdrawing this, there will be the opportunity to vote in relation to the clauses 126 and new clause 7 later on. Is that okay? Right. In that case, is everyone content for the amendment to be withdrawn? Those in favour? That's agreed. Thank you. Right, Amendment 288 to Clause 4 has already been debated with Amendment 345. I don't know whether there is Sean Woodcock to move the amendment formally.
Which one are we on to?
Amendment 288 to Clause 4 has already been debated with Amendment 345. Okay. Amendment 288 to Clause 4 is on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. No. Division. Are we ready to proceed? Okay, thank you. Lock the doors.
Jack Abbott? No. Lewis Atkinson? No. Juliet Campbell?
Aye.
Bambos Sharalombos? No. Daniel Francis?
Aye.
Sarah Green?
No.
Rachel Hopkins?
No.
Sojourn Joseph?
Aye.
Stephen Kinnock?
No.
Danny Kruger?
Aye.
Kim Leadbeater?
No.
Kit Malthouse?
No.
Sarah Olney?
Aye.
Dr. Simon Ofer?
No.
Rebecca Paul?
Aye.
Jake Richards?
No.
Sarah Sackman?
No.
Liz Saville-Roberts?
No.
Naz Shah?
Aye.
Dr. Neil Shastri-Hurst?
No.
Dr. Marie Titbull?
No.
Sean Woodcock?
Aye.
The ayes were 8, the noes were 14, so the noes have it, the noes have it. Unlock. Now, we now come to the question that clause 4, as amended, stand part. So the question is that clause 4 stand part of the bill. However, I understand that the Honourable Member for Reigate wished to make a point on clause 4 stand part in the clause 4 stand part debate. Now, I'm minded to allow a debate on clause 4 stand part, but I do remind members that relitigating and rehashing is really not something I would expect. It's a very narrow scope. It's not an opportunity to, as I say, rehash. It's simply whether the clause, as amended, should stand part. So with that caveat, I call the Rebecca Paul, and then we'll go on to other people. Rebecca Paul.
Thank you, Chair. I very much appreciate you giving me the opportunity, and I will attempt to be very, very brief. I just want to put one point on the record. Firstly, I'd just like to welcome acceptance of amendments Abbott 414, Billington 108, Atkinson 275, Johnson 341. I think the clause is stronger for it, so thank you to all the committee members for that. There's just one pertinent point with respect to clause 4 that I want to put on the record. So as this clause is dealing with what is and is not included in an initial discussion with registered medical practitioners, the definition of assisted dying and what it actually is becomes relevant in order that we understand what guidance does and does not come into play. So during these proceedings, there has been a tendency to speak as if assisted dying is another type of treatment or healthcare option being offered by medical practitioners rather than a completely different and separate offering. Many times it has been said that assisted dying should be treated in the same way as any other treatment, and that existing guidance from the GMC sets out appropriate best practice and should be applicable and relied upon. I have some concerns about this, which I just want to put on the record. So the legal norm and GMC guidance is that patients should be offered all reasonable medical treatments. A medical treatment can be defined as something that combats disease or disorder. It is fundamentally about healing, relief of symptoms, recovery and cure. So straight away we have a conflict. So assisted dying ends the life of the person. So it's not a treatment in the normal sense of the word, and it's important that it's not a treatment so that doctors are not obliged to offer it in the same way they would another more normal medical treatment. So in the Association of Palliative Care's written evidence, they cover this point too. So they say the following, and I quote, "A crucial question is whether or not assisted death by lethal medication is considered to be a medical treatment. Given that doctors are required to assess eligibility to prescribe and be present at the administration of the medication, assisted dying might be considered to be a medical treatment. If this is the case, then either assisted dying should be offered to all people meeting the eligibility criteria, or doctors need to behave differently towards this medical treatment than to all other treatments. Both these approaches are contrary to all prior medical practice and public expectation and laden with risks of unintended consequences. The Association of Palliative Medicine recommends that if assisted dying is implemented in England and Wales, it is done outside of usual medical practice and is not regarded as a medical treatment." And this is because there are detrimental consequences from classifying assisted dying as treatment and relying upon guidance. So firstly, it could undermine the doctor-patient relationship. It confuses the distinction between healing and ending life. Patients who are used to looking to their caregivers for help may worry that they will instead be put on a pathway towards an assisted death. This could deter them from seeking medical help when they need it. Dr. Jamelia Hussain spoke powerfully on this, so I won't repeat that. Secondly, the word treatment has largely positive connotations currently. So if this word starts to be used for assisted dying as well, its meaning entirely changes, and I worry about the intersection of this with other bits of guidance in law that refer to treatment. So, for example, where treatment is able to be legally given without the consent of the patient. We all here agree that assisted dying should never be administered without consent, but that is why we must be careful with our language and definitions. Treatment can, in certain situations, lawfully be given without consent. So it must follow that to protect from the risk of unintended consequences, that assisted dying is not deemed to be a treatment. On this basis, I would just close by saying I'm grateful for the Minister's view on this risk. And I note that there is no reference in the bill to it being a treatment, which is really good news. And his advice on how best to ensure assisted dying is not and never will be considered a treatment as a consequence of this bill, any other piece of statute or any guidance. And I would also be grateful for the Minister's view on the appropriateness of relying so heavily on GMC guidance for best practice, which I would imagine could change at any point in the future without the consent of Parliament. Thank you so much.
Thank you. Now, at this point, I'm not necessarily going to call anybody unless people particularly specifically wish to speak, and that includes the Minister for that matter as well. So if people do wish to speak, please, Bob, and I'll pick you up. Danny Kruger.
I'm very grateful. I think we've just concluded one of the most important debates we're going to have on Clause 4, and I very much welcome the concession by the Honourable Lady on, particularly on the commitment to modify the obligation to refer. I think that's very welcome and will make the bill a little safer. The point to the whole clause, though, Mr. Chairman, is that we've had clear confusion in the course of the debate, as my honourable friend just mentioned, about the extent to which assisted dying is a healthcare treatment. And this speaks to the question of whether it is an obligation for doctors to offer this treatment, as it should be if they're dealing with a treatment that the patient is eligible for. It's one of the range of options, or it's something they're not obliged to offer. And the confusion remains, and we had it in the exchanges. So I wanted just to record for members' memory the fact that that question was unresolved and, in my view, extremely unsatisfactory. We've just decided, despite some concessions which are welcome, to reject a series of amendments that would have protected both doctors and patients, including, most concerningly, the right of children to be protected from the suggestion of an assisted death before they're actually even eligible for it. And I want to conclude by referencing some new, not new evidence, but evidence that hasn't been referenced, I don't believe, in the debate so far, about the whole question of how assisted dying is received as a suggestion or as an offer, particularly by marginalised groups. And I was very concerned when we took oral evidence from Professor Ahmedzai, who supports assisted dying. He explicitly said that he especially wants the option to raise it with, and I quote, patients who are poorly educated, ill-informed, or seem to be unaware of the option. He explicitly required and requested the opportunity to put it to these disadvantaged, marginalised patients, poorly educated and ill-informed people. Compassion in Dying, which is the sister organisation of Dignity in Dying, who are supporting this bill, they make the same point. They make the point that marginalised people need to be, I quote, directly prompted with the offer. So I'm afraid to say, in rejecting the amendments, the committee has endorsed this approach, which is that people who are particularly marginalised and disadvantaged need to have this suggestion explicitly made to them. I am astonished that the committee is proposing to proceed on that basis. I think it completely misunderstands the dynamic of vulnerable people in the face of authority. I am very, very distressed to find that the committee thinks that it's an acceptable way to proceed. So I'm very sorry that we are proceeding, apparently proceeding, with this clause. I don't propose to push it to a vote, Mr. Chairman, because the will of the committee is fairly clear that it wants to proceed, but I hope everybody is fully aware of what they're doing. Thank you.
Thank you. And now, Sharp.
Thank you, Chair. I wish to rise briefly, really, just to express and put on record my disappointment. When we talked about various amendments about, and they were touched upon today in the amendments in relation to language being used and how doctors, how some patients would see it as a suggestion rather than an option. And I make no apologies that during the debate I said this could be, for me, it could be the next Horizon, it could be the next scandal, and that's not something, the blood scandal, and that's not something that I wanted to be, I struggle with that. But one of the things that was really stark, somebody sending it to me, was the chap Nick Wallace who actually exposed the Horizon scandal. And he said something very, very pertinent, and I do want that on record. He said the difference is there won't be anybody else left to campaign.
I'm trying to be as, I said earlier on, I'm trying to be as much lateral room as possible. I genuinely am. But the question is whether the clause stand apart. That's the key point. That's the question we've got to ask ourselves now.
Thank you, Chair. So whilst I won't oppose this stand clause part 4, I do want on record my disappointment that we didn't go further in putting in safeguards that we had the option to do during this debate. Thank you.
Thank you. Sorry, can I just, for members' benefit, as we're coming towards the end of this one, I do want people to be able to express their opinion, as I said, as widely as possible. But I think it's also a responsibility on me as the chair to make sure that that's contained within the parameters set by our rules, debate rules. Daniel Francis.
Thank you, Chair. I will be brief. Thank you for that, Mr. So as we reach into clause 4, obviously we've discussed amendments, and again, it's a regret on my part of some decisions that we've made. I know and I welcome that we will in due course discuss Amendment 418 in the name of my honourable friend from Spen Valley, which does put further discussion about preliminary conversation. My concern remains that that is a preliminary conversation, not in my determination the preliminary conversation. And I think my amendments would have meant that the preliminary conversation couldn't have been held before you were 18. And the way I read 418 is there could be preliminary conversations before you're 18. It's just you will recall that there was a preliminary conversation after you were 18. And it's with regret that I think that clause 4 now stands in that part that the bill says paperwork initial discussion at 18, but not necessarily preliminary conversation. Equally, with regret on some of those learning disability issues, of course I absolutely welcome the commitment from my honourable friend from Penniston and Stocksbridge on the matter that she aims to bring forward. I'm obviously conscious that when we debated that, the amendment she aims to bring forward isn't currently there on the order paper for everybody to see, but in the way she committed to work with me, I will continue that commitment to work with her and bring that forward. But I think we've debated this on a hard chair, but we do have a clause 4 which I do believe has those loopholes for people before they're 18 and people with learning disabilities and autism. It's with regret, again, I won't move to a division, but it's with regret that we've reached this place, Chair.
Thank you. Thank you. The question is that clause 4 stand part of the bill. As many as of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Clause 5 amendments 271 and 272. So we now come to amendment 271 to clause 5 in the name of Dr. Andrew Mullison, with which it will be convenient to consider amendment 272. However, I understand Sarah Olney or Daniel Kruger may wish to move this. If that's the case, Sarah Olney to move amendment 125. 271.
Thank you, Chair.
Beg your pardon.
Thank you for calling me to speak to this amendment. I won't take up a huge amount of time because a lot of what I'm going to say has already been said in previous sessions, but it's just to return to this issue about people who may be requesting an assisted death who may also be suffering from a mental health condition. And this, this amendment, tabled by the member for, I think, South West Wiltshire, but I'm not sure. Thank you. It's very specific about people who have received their terminal illness diagnosis within 6 months. So it is less than 6 months since they received their diagnosis, as well as obviously being within their prognosis is less than 6 months from now. It is specifically addressing the fact that the risk of suicide for people who are suffering from a terminal illness increases when the diagnosis has taken place less than 6 months before. Research by Professor Lewis Appleby, who is one of our key academics in the area of suicide prevention and advises the government on suicide prevention. Research by him and by Professor Sleeman found that diagnosis of severe conditions was associated with an increased risk of dying by suicide, and in particular that the increase in risk was more pronounced in the first 6 months after the diagnosis or the first treatment. And they concluded that a diagnosis of severe physical illness is associated with a higher suicide risk. The interaction of physical and mental illness emphasises the importance of collaborative physical and mental health care in these patients. We talked at length in an earlier session about the risk that bringing in an assisted dying law would undermine efforts to address the issues of suicide and suicide prevention strategies. I think it is so important that we return to this issue, that we look seriously at the Member for South West Yorkshire's amendment here, because I do think it addresses the very specific concern around, for those people who have had their diagnosis of terminal illness for less than 6 months and are therefore at a heightened risk of suicide. NICE guidelines say that if someone is at risk of self-harm or suicide, a clinician must ensure a psychosocial assessment has been carried out, either by a mental health specialist or by a trained person in primary care. That should cover the person's living arrangements, their relationships, their social support network, mental health disorders, risk factors, safeguarding concerns, and so on. Professor Alan House told the committee during the oral evidence session this should be part of the assessment for assisted dying, saying that the current assessment only answers the question, is this person able to make decisions? It does not cover the psychological and social assessment. We have, as I say, discussed at length the lack of the psychosocial assessment in relation to everybody who makes a request for an assisted death. But what this amendment seeks to do is identify those who are at heightened risk of suicide, those who have received their diagnosis of terminal illness within the last 6 months, and specifically requires that psychosocial assessment for those people. Now, depression is a common issue with terminal illness. Dr. Price from the Royal College of Psychiatrists told the committee that amongst people nearing the end of life, depression is around 20%, which is much more common than in the general population. Depression is strongly linked to a wish to hasten death, and that wish is significantly alleviated if depression is treated, which is, I think, an extremely important point for the committee to consider. In written evidence, the Pathfinders Neuromuscular Alliance, a user-led charity for those with muscle-weakening conditions like muscular dystrophy, say that Pathfinders members have outlined how important it is to ensure psychological assessments are part of the process in order to ensure that the individual is in a position to make an informed decision. One member outlined, "I've been there, I've wanted to die, and I've been in the position where I would take that option if it was given to me, but looking back, I can see I was depressed, and now I'm so glad that I didn't take that option." At present, the bill does not require anyone to explore any psychosocial factors in someone's situation. Although the person can be referred to a psychiatrist under Clause 9, Part 3, that only covers a capacity assessment. Again, it only answers the question, is this person able to make decisions, and addresses none of the other relevant factors. In Oregon, there is more room to explore those factors. The doctor may refer a patient for counselling if the patient may be suffering from a psychiatric or psychological disorder or depression causing impaired judgment. Addressing the risk of social pressure and internalised feelings of burden. The British Geriatric Society, in their written evidence, warned that there's an established link between frailty and feeling a burden to others, meaning many older people with treatable clinical frailty may choose an assisted death to avoid burdening their family, which we view as unacceptable. The committee has already discussed at length the issue of older people or people with a terminal illness wishing to choose an assisted death motivated by the wish to save their family money. Dr. Jerome Wagland and David found that attitudes towards assisted dying change over time. Patients closest to death were least likely to want assisted dying, suggesting that fear of suffering is the driving cause and may lessen as end-of-life care improves. Psychosocial care is fundamental to good end-of-life care. Members of the committee and witnesses from other jurisdictions have said that palliative care and assisted dying can complement each other, and this assessment should be part of the picture. Dean Berry told the committee about the importance of the psychosocial aspect of palliative and end-of-life care. The British Association of Social Workers, in their written evidence, say that good healthcare is not just about clinical interventions, but also about the wider social context in which a person lives their life. This is particularly pertinent with assisted dying. This needs to come before the first declaration, because once somebody has signed that declaration, they are already on a pathway. So this amendment provides an opportunity for people's needs to be met at the first opportunity. In conclusion, Chair, just to emphasise the importance of a psychosocial intervention was stressed by a number of witnesses giving oral evidence to the committee. We have discussed at length and earlier amendments have been voted down, but I just want to stress the particular importance of this one for that group of people who are in the first months of their terminal illness diagnosis and the raised level of risk of suicide that they present. Thank you, Chair.
Thank you. Amendment to Clause 4, as on the amendment paper. The question is that the amendment be made. Minister.
Thank you,
sorry, Sojourn Joseph. Could people bob if they wish to speak, please? Thank you.
Thank you, Chair. Again, as the honourable member said, this has been repeatedly discussed, repeatedly debated about people's mental health and how once somebody has had a diagnosis of terminal illness can have an impact on their decision making. This evidence that the amendment we discussed, Amendment 425 earlier today, about having access to a multidisciplinary team. That team could have a social worker in the team, a psychiatrist in the team, would have a comprehensive assessment which should have covered the amendment as just the Honourable Lady debated. So I think this is an opportunity for the committee to look into this, to make this bill more strong and bring in safeguard to vulnerable people who may be feeling suicidal, may be themselves feeling as a burden to the society or feeling a burden to the healthcare system, would choose this way. So those people who are vulnerable will have an assessment, a psychosocial assessment, a mental health assessment, will make this bill stronger and safer. Thank you.
Thank you, Chair. I speak against this amendment. I think there's significant issues with it both in practice and in principle. In terms of in practice, I would draw members' attention to the fact that this does not talk about a psychosocial assessment. This talks about mandating a psychosocial intervention. A psychosocial intervention, as defined by the World Health Organization, can be as brief as 5 minutes. In a brief intervention, I know I used to manage services delivering psychosocial interventions. In no way in this amendment does it specify what type of psychosocial intervention, the purpose of it. So if members are hoping that this amendment will lead to a psychosocial assessment, yes, of course it will.
Can I just clarify? If it did specify psychosocial assessment, would the member be minded to support it?
I think the holistic assessment is already set out elsewhere in the Act, and therefore this is not the draft bill, and therefore this is not required. The amendments to Clause 4 that we've just made already require all appropriate psychological support to have been discussed with an individual in advance of first declaration. I clearly supported that amendment, as I'm very grateful that the committee did. I also think, from a practical point of view, it talks about 6 months from the point of diagnosis. If I've had prostate cancer, I might have had prostate cancer for absolutely years. Is it 6 months from the point of being diagnosed as prostate cancer? 6 months from the point of being told that that's terminal? There are a huge range of practical issues about the amendment as currently written, but at the principle as well. I think fundamentally this comes from the point of an intervention that 100% of people need to be told that it starts with the assumption that there is something wrong with you if you've received a terminal diagnosis, and that you need to have your head, persuaded of the fact that exploring your options is not the right thing to do. And that is fundamentally wrong. There are, of course, genuine issues and concerns around and the tragedy of suicide where that occurs in all cases, but in the instance of following terminal diagnosis, as the Honourable Lady has set out. But a prevention strategy should not start with assuming that everyone requires a psychosocial intervention, regardless of screening, regardless of risk factors, regardless of any assessment. Yes, of course.
I would not accept, though, that the risk factors of a terminal illness in itself is a risk factor for an increased risk of suicide, but also that risk is increased in the first 6 months following the diagnosis, and that's what is the thinking behind this particular amendment.
I do accept that is a risk factor, but by no means is it determinative, and therefore we should not. That risk factor has to be considered in the round of other risk factors, levels of family social support. This amendment, as set out, doesn't distinguish between anyone who receiving a terminal diagnosis by themselves without any support network, for example, and someone who is expecting to receive a terminal diagnosis, having at the end of a very long illness. So I do not accept that we should be mandating psychosocial interventions, mandating that people must receive a level of healthcare in order for them to access other options related to their care, as a point of principle, let alone the practicalities, as I've laid out, about questions about when this would apply in relation to diagnosis, and the fact that it is an intervention. In no way is that an assessment or any such thing. Thank you, Chair.
Thank you. Minister.
Thank you, Chair. As I've made clear throughout the debate, I'm not offering a government view on the merits of these amendments. My remarks are focusing much more on the legal and practical impacts of amendments to assist members in undertaking the line-by-line scrutiny. These amendments have been tabled by the member for South West Wiltshire. They create a further eligibility requirement of the person seeking assistance under the bill. Amendments 271 and 272, if accepted, would limit those eligible to seek assistance to end their own life in circumstances where their terminal diagnosis was received less than 6 months prior to the date on which the person signs the first declaration, to those who have received a psychosocial intervention. This would be subject to any exceptions provided for by the Secretary of State in regulations. The amendment does not define what is meant by received a psychosocial intervention in relation to their diagnosis. The term intervention is usually employed in the health service to mean the provision of support or treatment. This is different from, for example, an assessment which a clinician might undertake to assess whether or not an intervention may be required. Whilst there isn't a standard definition of psychosocial intervention, we understand it to mean psychosocial interventions such as cognitive behavioural therapy. This could create uncertainty as to what type of treatment a person will need to undergo in order to satisfy this requirement. If a person who would otherwise seek assistance to end their own life under the bill is unable to or does not wish to receive a psychosocial intervention unless an exemption applies, they may need to delay starting the assisted dying process until at least 6 months has elapsed from their terminal diagnosis. This could be challenging in circumstances where the terminal diagnosis has a prognosis of 6 months or less. This amendment also introduces a requirement for people in certain contexts to undergo an intervention, which could undermine a person's autonomy in making their own treatment decisions. If this amendment is made, it would confer a regulation-making power on the Secretary of State to create exceptions to the proposed provisions on psychosocial intervention. Regulations made using this power would be subject to the affirmative procedure. It would also give the Secretary of State the power to issue a code of practice in connection with the form of the psychosocial intervention required. If the committee decides to accept this amendment, further consideration would be needed for report stage to ensure that it is operationally deliverable, my comments made earlier around the definition of psychosocial intervention and other comments would have to be clarified. The government would of course stand ready to assist if the amendment were to pass. As I said earlier, the government's taken a neutral position on the substantive policy questions relevant to how the law in this area could be changed. That is, as I've made clear, a matter for this committee and Parliament as a whole. However, I hope that these observations have been helpful, and I thank the committee for its attention. Thank you, Chair.
Thank you, Chair. I've got nothing to add. I would associate myself with the comments from the Honourable Member for Sunderland Central and the Minister.
Amendment 271. Proposed to clause 4 as on the amendment paper. The question is that the amendment be made. As many of the opinion say aye. Aye. Contrary, no. No. Division.
Division room 10.
Colleagues content? In that case, lock the doors.
Jack Abbott. No. Lewis Atkinson. No. Juliet Campbell. No. Stambos Chalambos. No. Daniel Francis.
No.
Sarah Green. Pardon, sorry. No. Rachel Hopkins. No. Sir John Joseph.
Aye. Stephen
Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
No.
Jake Richards. Sorry. Sarah Sackman. Sorry. Liz Havell-Roberts. No. Naz Shah.
No.
Dr Neil Shastry-Hurst.
No.
Dr Mary Tidball.
No.
Sean Woodcock.
No.
Thank you. The ayes were 4 and the noes were 16, so the noes have it. The noes have it. Unlock. We now come to Amendment 184 to clause 5 in the name of Kim Leadbeater, with which it will be convenient to consider Amendments 289, 418, 277, 420, 195, 209, 220, 421, 203, 204, 329, 307, 330, 331, 208, 332, 333, 214, 334, 403 and 404. I call Kim Leadbeater to move Amendment 184.
Thank you, Chair. I rise to support my amendments in this group, which seek to clarify the details that must be included under regulations in the first declaration and the report that is consequent on that declaration. While I believe it was useful at second reading for MPs to be aware of the content of the form the doctor should complete, the advice I've received, which I agree with, is that these details are more appropriately a matter for regulations. There is always a balance to be struck, but it would not be reasonable to expect the House to have to consider changes in primary legislation. Oh gosh, I'm tired. Sorry. To primary legislation, simply in order to alter the contents of a declaration, important though those details are. And the changes proposed go further in a way that I believe should greatly reassure the committee. As we discussed this morning, they make clear that a person must have been over the age of 18 when the first discussion under the bill took place. It also requires the doctors should not just to make formal declarations, but to produce reports covering the eligibility of the person to request assistance, and also the nature of the assessments they have made and the discussions with that person, and crucially their understanding of those discussions and of what the process entails. This will ensure that all the relevant discussions have been recorded and have been understood, and that an account of them has been recorded and will be available for future reference. And for reporting purposes, if a person applying for assistance is found not to be eligible, that information will be recorded too. I hope the committee will agree that as a result, once again, further safeguards will be put in place without imposing additional stress or burdens on terminally ill patients at such a difficult period.
Amendment 184 to clause 5. As on the amendment paper, the question is that the amendments be made. Kit Malthouse.
Mr. Chairman, I'm very grateful to you. I rise to speak in support of 184. And also to point out that in the previous groupings 329 to 334 I have now withdrawn, so they won't appear for voting later on in the bill. Like the Honourable Lady, I had thought that while it was sensible to have schedules to the bill for second reading that laid out the form, first of all they were quite limited and strict in their form, and therefore we needed more flexibility, and in particular the opportunity by regulation for the House to add content to the required forms in the future. But also critically, I wanted to insert a declaration by the person that they had had the initial conversation, that had covered all the factors that are in the bill, and critically that they understood the information that had been presented to them. And Amendment 184 does exactly that. Just for reference for members, there are similar amendments by me throughout the bill, doing the same with the other schedules. In conversation with my honourable friend for Spen Valley, I have now withdrawn all of those and amalgamated them into the amendments that do the same that she's put in place, along with some additional bits and pieces. So it's a relatively self-explanatory amendment. I did, though, also want to speak particularly against Amendment 277. Which imposes a time limit of 28 days between diagnosis and first declaration of a terminal illness, and also to point out that in quite a lot of circumstances this would actually be a very difficult time delay for people to face. As the Honourable Lady who's proposed the amendment will know, there are already periods of reflection within the bill, albeit that the bill also contains a provision for a compressed time limit for those who are facing a very imminent death. But adding 28 days to particularly those who unfortunately are diagnosed with certain diseases will insert a delay at a time when people who are facing what they do not want to face, a horrible death, need as much time as they can to get through the process. So, for example, if you take together all the factors for people with, sadly, who are diagnosed with pancreatic cancer, the median survival is 6 to 12 months. I don't know if the Honourable Lady knows, but pancreatic cancer is a particularly unpleasant cancer, not least because it doesn't exhibit symptoms in its early stages. People don't actually know they've got it until quite late in its development. Treatment for it is not well advanced, and many people are diagnosed with pancreatic cancer with sometimes only weeks to live. The idea that in all those circumstances we should make them wait 28 days before they can even start the process would seem to me impractical and in many ways, I'm sorry to say, cruel towards them. It's worth pointing out to members to remember again that this is not a 6-month bang, I go and do it. Right? Most people who have a terminal illness will begin the application process at 6 months. Once they have the ability to ask for this service, they will then wait until they decide that their life has come to its end at the time and the place of their choosing. Now, that might be at 6 months, that might be at 6 days. The point of the bill is to put the power in their hands to make that decision. So, while the bill does have periods of reflection, it recognises that people need to sit and think about these things. Imposing an absolute 28 days on everybody with no account of what stage they're at in their disease, how long they've got to live, seems to me to be not necessarily a sensible amendment to put forward, and I will be opposing it from that point of view. As to 403 and 404, which is the amendments about informing family that the Honourable Gentleman's put down, I understand his objective in putting these down, and I would hope that perhaps one of the doctors who are on the committee can tell us, I would hope that this is the sort of discussion that doctors would have. Whether we should put that on the face of the bill, again, and I've been persistent in this view of kind of trying to make sure that the conversation is not guarded. The fact that the amendment says that you just want to know whether I haven't, or I haven't got any family, not quite sure what family means. Does it mean my children? Maybe I don't actually want to tell my children. Does it mean my next of kin? I don't know. Is it distant relatives? Is it my whole family? I think there are problems with the definition of family. But as I say, while I won't be supporting that amendment, I understand what the Honourable Gentleman's trying to do, and I would hope that in the conversations with doctors, those are the kind of sensitive matters that a doctor would tease out of an individual as they look for the various items that we've put in the bill, to make sure that the person is making a decision on a sound basis as a settled view, and that they have the capacity to do so. Thank you, Mr. Chairman.
Thank you. Danny Kruger.
I'm very grateful. Thank you, Mr. Chairman, and grateful to the points made by my right honourable friend. I just want to speak briefly to these amendments, which would create an opportunity, in fact an expectation, that a patient does at least address the question of whether his or her family is aware of the decision that they are making. And my proposal, I think in an amendment that has not been selected for debate today, but it is simply to make this expectation clear. I mean, my personal view is that I don't accept it's healthcare, and therefore I would have an obligation on a doctor to ensure that the next of kin of somebody that they're proposing to give lethal drugs to is informed. But I recognise in the spirit of the bill, which is all about autonomy, and an attempt to be constructive and to put forward amendments that might be accepted, I accept that this is a decision for the individual in the way that a healthcare decision is, and that therefore there is no obligation under rules of patient confidentiality and the expectations around healthcare that the family should be informed. Nevertheless, I do think creating a moment at which the first doctor that they speak to does gently encourage them to consider telling their family before taking this enormous step of signing that first declaration is appropriate. And there are three options that the amendment would give to the patient. First, that they confirm that they have informed their family of their wish to be provided with assistance to end their life.
Order. I understand the Honourable Gentleman does want to touch on this, but it hasn't been chosen for today. The Honourable Gentleman is talking about the declaration that the person, they have informed the family of their decision and taken their opinions into consideration. We're not dealing with that today.
Nevertheless, 403 and 404 are being selected for debate, and it's them that enable this amendment to be effected in the bill.
I think the Honourable Gentleman just takes the sort of the spirit of what I'm saying into account.
Right, well, I'm grateful to you, Mr. Chair. I want to quickly, if I may, just explain why I think these amendments are appropriate to the bill. The patient would therefore have the opportunity to declare quite clearly that they don't have they either don't have a family, and I take my right honourable friend's point, it's not always clear what a family is. Nevertheless, if they want to specify, I have no family, or I do not want to inform my family, then that would be the right that they had under this bill. But I do want to emphasise the importance of this consideration. And by the way, I recognise that in clause 9, a little later in the process, there is the consideration of the family. The doctor may, insofar as the assessing doctor considers it appropriate, advise the patient. So there's a recognition of this whole question about family, the informing of the family a little later. But my suggestion is that should come early, because it needs to take place at that moment before the first declaration is signed. The crucial thing, though, Mr. Chairman, is we need to consider the wider impact of not considering the family, not involving the family, particularly when there are children or dependents involved. And this bill accepts the scenario where a family can find out after the fact, not through any formal notification, they just discover that their loved one has ended their life with the help of doctors, with the help of the state. Now, families can be badly impacted by an assisted suicide. clinical grief disorders, depression, PTSD are all harms that can follow from a family member taking an assisted death. And it is unethical and irresponsible, in my view, not to factor this in as we discuss this bill and as we design the new law. A parent may choose to end their life under this bill. It is not required in any way to consider notifying their family. I mean, I wonder if the sponsor could clarify what would happen if they were the sole carer of a minor, and would there be any obligation for anybody to inform even the child that this was happening? I know it's an extremely rare scenario, one hopes, but nevertheless it is possible under this bill. And just two more groups I want to quickly mention, Mr. Chairman, before I'll stop. In written evidence, a group of anorexia sufferers and carers say this: the bill does not anticipate situations where somebody seeks to end their life as a result of cognitive symptoms inherent in the illness, as is the case with anorexia nervosa. For these patients, families would often need to advocate for their loved ones and their potential to recover. Without family involvement, patients may take decisions in isolation, potentially influenced by cognitive distortions or feelings of hopelessness inherent to the illness. I hope we don't think that that's a scenario we want to allow. And then, finally, Dr. Jamila Hussain, who we've heard from a few times, she says in written evidence, specific to particular minority communities, my consultation with structurally disadvantaged ethnic minority groups, including Pakistani, Roma and Black Caribbean community groups, she says there was much concern about the exclusion of families. It was emphasised that traditionally family and community members provide hope and strength when someone feels like life is too much. There is apprehension that such expressions of care and support could be reframed through a medical or legal lens as coercion. And Mr. Chairman, this is the saddest thing, and we heard it hinted at quite strongly, in fact stated explicitly in some of the evidence sessions we had, that wanting your loved one to live is seen by doctors as a form of coercion which should be resisted. It's been suggested that trying to argue your loved one out of an assisted death, that's the coercion we need to guard against. And on that basis, we shouldn't be making any expectation that families are informed. What a tragic thing for us to be saying. And to enable doctors to issue lethal drugs that kill you without your family knowing. What an absolutely tragic thing. And I just beg the committee to consider what on earth are we doing allowing that. Thank you.
Thank you. Can I apologise to the member who was within his rights on this, member 404. Thank you very much. Can I have Nice Shah next, please?
Thank you, Chair. I rise to speak to my own amendment 277. This would add a new subclause to clause 5. As with my amendment 276, it alters the time that can elapse between a person receiving a diagnosis of severe illness and their discussion of assisted dying with a medical practitioner. To put the most important point first, it aims to prevent people opting for assisted dying whilst they are suffering from the initial shock of having a serious illness diagnosed. This amendment would impose a pause. There would have to be 28 days between when a person received a diagnosis and prognosis of the illness that might end with their life within 6 months, and when they could have their second consultation with a doctor about assisted dying. I appreciate the member for North West Hampshire who asked me whether I understood or whether I was aware of pancreatic cancer. A dear friend of mine, he was actually known as the King of Curry in Bradford. I remember him telling me only in June, the day I launched my election campaign, funnily enough, that he was diagnosed with terminal cancer. In October he was gone, so I'm overly familiar with the issue of pancreatic cancer and how fast he went down from being a healthy individual to a greatly missed individual Bradford person. The committee has already rejected Amendment 276, and I would ask all committees to members to think again, and in particular to consider the evidence given to us by several distinguished doctors, including senior psychiatrists. What those doctors said to us, Chair, in written and spoken evidence, was that immediately after someone has received a diagnosis of serious illness, they often experience a major increase in depression and a desire to hasten death. For some patients, this desire to hasten death is what psychiatrists call an increase in suicidality. That is, the patient wants to actively do something to end their own life. For other patients, they do not have an active desire to carry out a physical act to end their life, but they do wish that their life would end sooner. We can all empathise with people who have just received such a shocking diagnosis and prognosis. They have been told that they are likely to die soon. They may also either have been given information that makes them think their remaining months of life will be degrading and painful, or they may assume that it will be. That might well be how many of us would think if we had such devastating news. But the psychiatrist who gave evidence, Chair, also said that the depression and desire for death are often not permanent conditions for people who have received these diagnoses. When a patient gets treatment for their physical symptoms, plus social care, and if necessary, psychological treatment, the desire to hasten death will often fall. Let me refer to the evidence of Dr. Annabel Price, Vice Chair of the Royal College of Psychiatrists Liaison Faculty. And I appreciate, Chair, I am repeating some of the things I've mentioned previously, but when I've spoken previously in referencing this evidence, it has been to other amendments, hence I'm having to repeat it for the purpose of this amendment in particular. She said there was a lot of research evidence around depression in people with palliative care needs and people nearing the end of life. We know that depression is common, and across a number of studies it is around 20%, much more common than in the general population. We also know that depression is strongly associated with a wish to hasten death, and that if depression is found and treated in that group of patients, there will be a significant change in the wish to hasten death. Dr. Price said there were a number of factors beside depression that were associated with the wish to hasten death in those who had received diagnosis of serious illness. She said to us, they include difficult symptom experience, poor functional status, needing a lot of help with things, and being socially isolated. Those are the really key ones. They also include a sense of loss of dignity and feeling like a burden upon others. Patients who have all these factors, Dr. Price said, find they can all come together to make life feel very unbearable. What was perhaps the most important part of Dr. Price's evidence was when she said what good medical and social care could do for people who felt their lives were unbearable. She said the evidence that we have from research about populations who would fulfill this Bill's criteria in terms of terminal illness, and I quote her, is that the prevalence of depression in people who is around 20%, that is across a number of populations, it is associated with a wish to hasten death. She went on to say, Dr. Price went on to say, depression might impact upon that person's decision making. I'm not saying that it absolutely would, but it might. Also, treatment might change their view. We know that there is a strong association, for example, between pain and a wish to hasten death. Happy to give.
I'm very sorry. I just wanted your guidance. Chair, obviously the Honourable Lady is giving a speech which I'm afraid we have covered before. We've had extensive debates on the impact of terminal diagnosis on people's mental health and depression. And I just wanted to get your guidance on what we should be in the committee doing to arrest or resist the temptation to repeat debates that we've already had extensively while we're considering these amendments.
Thank you for that. I reiterate the point I made on a number of occasions, is that I do not want to interrupt members when they're making a point, because we're on a very sensitive situation. We're in a very sensitive situation. That has no doubt. So I exhort members when they are discussing these things to bear in mind these factors and these issues. Sharp.
Thank you, Chair. Before I carry on, might I just add, and I appreciate, and I just did refer to this, and I appreciate the member's point of order, that actually these things speak to this particular amendment of 28 days. So whilst they speak to many other debates, we will have no doubt in this bill committee many things that relate from one piece of evidence that cross over many, many amendments. And it's because of those amendments, I assure the committee chair that my intentions are just to particularly draw attention to those in relation to the particular amendment I'm speaking to. So I appreciate that there is huge repetition but this, for a better word, for myself, I feel it is necessary unless advised otherwise, and I'd be happy to take the guidance of the Chair. Coming back to the speech where I was, we know that there is a strong association, for example, between pain and a wish to hasten death. Unresolved physical symptoms make people want to die, and when that pain is better, people no longer feel that way. I am still quoting Dr. Price, and I would ask committee members to listen very carefully to this next part. That is borne out in my clinical practice. We will get urgent referrals to see somebody who wants to die and who they are very concerned about. Then the pain is under control. We see them that day or the next day and they say, do you know what? The pain is better. I don't feel like that anymore. Dr. Price told us, when we think about symptoms, we need to think carefully about what is treatable and what is remediable. That may be about psychiatric intervention, but it is also often about biological, psychological and social approach. We need to consider those words from an experienced psychiatrist very carefully. She is telling us that because it's what psychiatrists as a profession have learned from rigorous large-scale studies of people who have been given diagnoses of serious illness, she is telling us that because it's what she has seen in her own practice as a psychiatrist. This bill should give patients who have been diagnosed with serious illness and prognosed with 6 months to live the time to think if they want assisted dying. And as Dr. Price told us, it should give these patients and doctors and the social care authorities enough time to put the right medical and care treatment in place. If we look in detail at the bill, I'm afraid we have to conclude that it does not do that. That is why I am asking all members, honourable members, to consider voting for this amendment. When this committee discussed Amendment 276 prior to rejecting it, my honourable friend for Stroud rejected the need for a 28-day waiting period. He said, and here I quote from the Hansard record, "With the panel also involved, there will be more than a month between the first time the patient sees a doctor and when they actually get a decision that they can end their life. I do think that protects. I would support Amendment 276 because it is important that people do not say, right, I would like my life to end now and not to give due consideration, but due consideration is already written into the bill." And I thank my honourable friend from Stroud for those thoughtful and courteous words on this amendment. But I want to explain why I disagree with his reasoning. As I make it, if the committee accepts the amendments moved by my honourable friend for Spen Valley, creating assisted death panels, there will be a total of 21 days' worth of reflection periods between the first time the patient sees a doctor and when they actually get a decision that they can end their life. There may also be time when the panel is deliberating. However, as the bill is, that isn't clarified and no doubt will differ from patient to patient. Furthermore, and perhaps most importantly, those 21 days would not come as one pause for reflection. Rather, they would come 7 or 14 days at a time in between stages of the process to apply for assisted dying. I will break this down for committee members. First of all, the bill does not at any point state that there must be a time interval between a person receiving a diagnosis of serious illness and a prognosis of death being likely within 6 months, and that person having their initial discussion with a medical practitioner. Indeed, under the bill as currently written, a doctor could give a patient a diagnosis of serious illness and a prognosis of likely death within 6 months, and then, in that same room, at that same time, while the patient was immensely shocked, the patient could then talk to a doctor about assisted dying. This seems to have considerable risk to me. I note in passing, as this is a matter covered by other amendments, that the doctor could firstly give the patient their diagnosis of serious illness, secondly, give them their prognosis of 6 months to live, and then third, raise the option of assisted dying with them. Secondly, the bill says there must be no pause between a declaration between a person's initial discussion with a registered medical practitioner and the coordinating doctor. Clause 7, subsection 1 reads as follows. the coordinating doctor must, as soon as reasonably practicable, after a first declaration is made by a person, carry out the first assessment. In other words, a patient shocked by their diagnosis and prognosis could have a first doctor's assessment of their desire for assisted dying as soon as that patient can make an appointment with a doctor willing to discuss the matter. Again, this seems to carry enormous risks for me. Some patients will have the immense strength of mind needed to weigh the facts that they have been given as rationally as possible. Others will understandably be in immense shock and will be looking for a rapid exit from what they may fear will be a horrible death. The first period of reflection comes only after the end of the first doctor's assessment. There are serious concerns with this. It means it comes after the patient has taken 3 steps on the path to assisted dying: the initial discussion, the initial statement, and the first doctor's consultation. And this period of reflection does not come after the patient receives their diagnosis and their 6-month prognosis. What we heard from the psychiatrist is that this is when the patients with such diagnosis and prognosis most need 2 things. They need the time to reflect on the terrible news that they've just heard, and even more importantly, they need their doctors and their social care authorities to arrange medical treatment and social care and psychiatric support for their new diagnosis. If they receive these things, their desire for a quick death is likely to fall. But the bill doesn't provide that time. Another serious concern and problem with the bill is that the first 7-day period of reflection is too short to get things done. This 28-day waiting period would provide the doctors and social care authorities with much more time to arrange suitable treatment. Under the bill as written, if 2 doctors both believed the applicant was eligible for assisted dying, they would then send the case to the High Court. And I understand that my honourable friend from Spen Valley now wants to amend that process so that this case is now scrutinised by a panel of 3 qualified professionals. Once the case has been scrutinised either by a High Court or by a panel, then there will be a second period of reflection. This one will last 14 days. Again, there are some things that are very seriously wrong with this. It is too short. 14 days will not, in many cases, give doctors and social care authorities enough time to organise good treatment for a patient. It would make far more sense to give them a period of 28 days to organise such care and for the patient to consider whether they really did wish to opt for an assisted death. And let us think when is this second period of reflection must take place. It must take place after the patient has had their initial discussion of assisted death. It must take place after the patient has made their declaration that they are seeking an assisted death. It must take place after the patient has had their first and then their second consultation with a doctor and convinced both doctors that they wish to die. It must take place after the panel, which may, I stress, may call the patient in to check that they do indeed wish an assisted death. So when does this second period of reflection come? After a process lasting weeks in which a patient has had to convince doctors and possibly also the 3-member panel that they wish to die. That is not the right way to do things. We should give patients who have had a shocking diagnosis and prognosis much more time to reflect before they have effectively reached the end of the application process. And the bill refers to a period for reflection. It should not. I disagree with that term and the premise and the assumption behind it. This is not a disagreement about language. It is much more important than that. And I want to emphasise that the 28-day pause in my amendment is not just about reflection. It is about seeing if we can improve medical and social care for patients who so desperately need it. When that care is in place, they may still wish to opt for assisted death, but they may not do. We should not make this process too hasty. If we do, we will push many people down the path to an assisted death that, given the time to arrange better medical treatment and social care, and given the time to reflect, they perhaps would not do. I ask honourable members to support this amendment. This amendment will give patients time to think. It will give them that time near the beginning of the assisted dying process, whereas the bill currently gives them most time almost at the end of the process. And this amendment, most importantly, Chair, will give patients what senior psychiatrists have asked for. Simply put, the chance for people who have received shocking diagnosis and prognosis to work with their doctors and social carers to put new treatment plans in place. Thank you.
Thank you very much, Chair. And I rise to reluctantly set out why I cannot support my honourable friend's amendments 403 and 404, my honourable friend for East Wiltshire. And it's not because of the principle, because my honourable friend has been very clear in how he set it out. This is not a prescriptive situation where an individual must tell their family. It's set out a range of options that I would anticipate any sensible, responsible doctor and clinician would go through with a patient, and would encourage them to involve their family in this decision making. And this is why it is reluctance on my part. The issue I have is around the legal clarity of the wording of the amendment. Because under the English and Welsh legal system, there is no statutory definition of family. There is a concept of family, but the concept of family to me may be very different to my neighbour, may be very different to someone who lives in another city, for example. For example, for some people, stepbrothers, stepsisters, stepparents are very much part of their family. For others, they are not. For some, unmarried couples with children are a family. For others, they are not. For some, unmarried couples without children are a family, and for others, they are not.
Will you give way?
I will give way.
I'm very grateful, and I do take that point. Families are difficult to define. Nevertheless, the bill does currently make reference to the opportunity for a doctor, or suggestion that the doctor, in this, so far as they consider it appropriate, for the patient to consider discussing their request with their next of kin and other persons they are close to. And that's more precise. Would the honourable gentleman accept an amendment along the lines I've proposed, which is to make this prior to the first declaration, but using the language that is currently in the bill about the next of kin or people you're close to?
I'm grateful to my honourable friend for that intervention, because that would satisfy me. And the reason I say that is because at the moment the wording is too broad, it's too ill-defined. The question is this about the closeness and proximity of a relationship? The suggested wording that has been put forward would be much closer to that, would be much clearer in terms of what it defines, and would be more akin with medical registration when one turns up in A&E, Chair, when you're asked to give the name of your next of kin. That gives the definition of the closeness and the proximity and the permanency of that relationship. If my honourable friend was to reconsider perhaps withdrawing this amendment but retabling it in an alternative form or rewording it, that would certainly be something I would be open to supporting. But those are the reasons, as the amendment as it stands, I cannot support it.
Thank you. Minister.
Thank you, Chair. While it's for Parliament to decide whether or not to progress this bill, this government remains committed to ensuring that the legal robustness and workability of all legislation. For that reason, the government has worked closely with the member for Spen Valley, and some amendments have been mutually agreed upon by herself and the government. These are amendments 184, 418, 420, 195, 209, 220, 421, 203, 204, 207, 208 and 214 in this grouping. This grouping of amendments replaces the forms set out in the schedules of the bill with a requirement for the forms to be set out in regulations by the Secretary of State. These amendments also make provision about the content and form of the first and second declarations, statements and reports. Amendment 184 provides the first declaration must be in the form set out in regulations made by the Secretary of State, as opposed to in Schedule 1 as currently drafted. Operationally, using regulations will allow for consultation in relation to the form and content of the declaration. It will also provide flexibility to tailor or update the content of the declaration. The effect of Amendment 289 would be to limit the number of people able to act as a second witness to a first declaration to registered clinicians, though this term is not defined in the amendment. In normal usage, registered clinician is broader than registered medical practitioner, so practically the amendment may lead to a wide range of registered healthcare professionals being able to act as a witness to a first declaration under the bill. Looking at 418, Section 5(2)(a) of the bill at introduction sets out that a first declaration must be in the form set out in Schedule 1. Under Amendment 184, tabled by the member for Spen Valley, and which we have just discussed, the form and content of the first declaration would instead be set out in regulations made by the Secretary of State. 418 makes provision for the content of the regulations that would be made under subsection 2A, which would set out the form of the first declaration. Amendment 277 states that a person is unable to make a first declaration to be provided with assistance to end their own life until 28 days after receiving a terminal diagnosis have elapsed. The effect of this would be that those who are given a terminal diagnosis and who are expected to or go on to live for less than 28 days may be precluded from accessing assisted dying under this legislation. 420. As the bill is currently drafted, if having carried out the first assessment, the coordinating doctor is satisfied that the patient has made all eligibility requirements, the coordinating doctor must make a statement to that effect in the form set out in Schedule 2. This amendment seeks to replace the requirement for the coordinating doctor to complete the form in Schedule 2 with a requirement to complete a report with the information set out at Clause 7, subsection 3. The amendment includes a regulation making obligations so that the Secretary of State is required to set out in regulations the form and content of the report, including the details specified on the face of the bill. The coordinating doctor is required to provide a copy of the report to the person seeking assistance, to a registered medical practitioner at the person's GP practice, if the coordinating doctor is not at that practice, and to any other person specified in regulations. 195.209.220. These are three minor consequential amendments that flow from Amendment 420. Two are to replace references to the statement in Clause 8 and Clause 16 with a reference to the report, and the other is to Clause 34 to update the requirements of the Chief Medical Officer's report. 421. This amendment seeks to achieve a similar effect as Amendment 420, whereby the coordinating doctor is required to complete a report following the second assessment. It further makes provision for the content of that report in regulations. As with Amendment 420, this amendment puts a requirement on the independent doctor with regards to the second assessment that they must complete a report of the assessment and share with the relevant people as specified. This amendment makes provision for the content of the report to be set out in regulations, with particular details for which there must be provision in the regulations specified on the face of the bill. 203 and 204. This is consequential to 421, which provides that the independent doctor must make a report about the second assessment. 203 and 204 amend the provision at the start of Clause 10, subsection 1, referring to circumstances where the independent doctor does not make a statement. The purpose of Amendments 329 and 330 is to remove Schedule 4 of the bill and set out the minimum requirements for what information the second declaration must contain. There is a regulation making power to allow the Secretary of State to include other information or declarations to the second declaration. The information listed as required in this amendment are largely the same as those which currently appear in Schedule 4 to the bill, although there are some minor changes to the wording. 207. This amendment provides that the form associated with the second declaration is to be set out in regulations as opposed to Schedule 4 on the face of the bill. This would have the effect of providing flexibility to update the content of the declaration if required later. 331 and 332 is to enable some flexibility on the form and content of a second statement by the coordinating doctor to be set out.
Just to be clear, a number of the amendments that he's mentioned are in my name. have now withdrawn those amendments, albeit that they would not have been voted on until later stages, but I've withdrawn them in favour of the member Ben Valley's amendments, which broadly do the same thing.
Oh, I thank you for that clarification, because I had heard he was withdrawing, but I thought perhaps it was withdrawing in terms of not pushing to a vote.
No. I formally withdrew them earlier today.
Order. As far as I'm aware, they are still on the amendment paper. Well, let's not get too technical at this particular stage. Minister.
I will therefore go to Amendment 208. This amendment provides that the form of a statement provided by the coordinating doctor following the making of the second declaration is to be set out in regulations, as opposed to the current position where it is set out in Schedule 5 of the Bill. This would have the effect of providing flexibility to update the content of the form of the statement, if required later. Skip those. 214, this amendment provides that the form associated with the final statement is to be set out in regulations, as opposed to Schedule 6 on the face of the Bill. This would have the effect of providing flexibility to update the content of the form, if required later. Amendment 404 would mean that, following court approval, the person seeking assistance must confirm in a second declaration on the form set out in Schedule 4 whether or not they have informed their family of their wish to be provided with assistance to end their own life. From a practical perspective, this amendment does not specify how a family would be defined, and this may create uncertainty as to who the person would need to inform or how to determine that they have no family. This amendment requires the form of the first declaration set out in Schedule 1 to the Bill to capture whether a person seeking assistance to end their life has A. informed their family of their wish to be provided with assistance to end their own life and taken their family's opinion into consideration, B. decided not to inform their family of their decision, or C. has no family to inform of their decision. It is not clear how family would be defined as a term. It is also worth noting that this amendment would conflict with Amendment 184, which removes Schedule 1 to the Bill. I hope that those observations have been helpful to the committee, and I thank the committee for its attention.
Thank you. Kim Lead-Peter.
Got nothing to ask.
Okay, thank you. Amendment 184 proposed to clause 5 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. Amendment 289 to clause 5 has already been debated with Amendment 184. I call the member to move the amendment formally. Is anybody going to move it, rather? Is anybody going to move it? No? There's Amendment 289 to clause 5 has already been debated. I call them. Does someone want to move this formally? No, in that case, it's withdrawn. Amendment 418 to clause 5 has already been debated with Amendment 184. I call Kim Lead-Peter to move the amendment formally.
Move formally.
The question is that the amendment be made. As many as of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Amendment 277 to clause 5 has already been debated with Amendment 412. I call Nashar to move the amendment formally. Amendment 277 to clause 5 as on the amendment paper. The question is that the amendment be made. As many as of that opinion say aye. Aye. On the contrary, no. No. Division. Right, are we ready to proceed? Yes, lock the doors. Thank you.
Jack Abbott. No. Lewis Atkinson. No. Juliet Campbell. Aye. Aye. Lambos Cheryl Lambos.
No.
Daniel Francis. Aye. Sarah Green. No. Rachel Hopkins. No. Sojourn Joseph. Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney. Aye. Dr. Simon Ofer.
No.
Rebecca Paul. Aye. Jake Richards.
No.
Liz Saville Roberts. No. Naz Shah. Aye. Dr Neil Chestry-Hurst.
No.
Sean Woodcock.
Aye.
The ayes were 7, the noes were 12, so the ayes have it, the ayes. Noes have it, the noes have it. Beg your pardon. Long day.
I beg to move that further consideration of the bill be now open.
Further consideration of the bill has been, no further consideration of the bill has been moved. Those in favour? Aye. Those against? Order, the sitting is suspended.